Ladies and gentlemen, I think we are ready to convene the 90th meeting of the Massachusetts Gaming Commission, Thursday, November 14th, 2013, at the Convention Center in Boston. First item is usually the approval of minutes, but I don't think we have any minutes today.
We do not have any minutes, Mr. Chairman, but that will be remedied by our next meeting.
Okay. Then let's go straight to item number 3, a series of items from the Director of the Racing Division.
Good morning, Mr. Chair, Commissioners.
Morning.
Is the microphone? Yes, it is on. Okay. I have no administrative update for you today. I think I talked myself out last week, so we'll just proceed right to agenda item 3B, which is the consideration of the racing license applications.
All right.
Included in your packet were some draft decisions and then some supplemental materials that were received after the deadline for last week's packet that are in there. None of the materials that were received after the deadline alter our recommendations or conditions in any way as they were reported to you at last week's meeting. And so unless there's any discussion of the items that are presented, I would be happy to move right into the voting part of this agenda, if it pleases the chair. Happy to entertain any questions regarding any of the materials.
You're going to want to have a vote on each, right?
Yes, sir.
Right.
I think it would make sense just to have you go straight to the conclusion and recommendation part, just to remind us and everybody else, very briefly, what your bottom line is on the 3.
Okay, so in the matter of Sterling Suffolk Racecourse LLC, application to conduct running horse racing in 2014, we do recommend approval. We recommend approval subject to the following conditions, that the applicant shall work with the commission to ensure that key racing employees, once defined, are identified and subjected to an appropriate background check, that any amendments to existing contracts and agreements or newly executed contracts and agreements with representative horsemen's groups must be provided to the racing division within 5 business days of execution. The approval, should you choose to provide it, will also authorize simulcast wagering effective January 1, 2014, with the brick and mortar and other outlets listed in Exhibits 27, 28A, and 28B of their application, as well as the 3 advanced deposit wagering account providers listed in Exhibit 29, pending regulatory and representative horsemen's group approvals required by the Interstate Horse Racing Act and the Massachusetts general laws, and this approval would also authorize a 12-week premium-free period elected by the applicant.
And so any motion to that effect? Or they will discuss?
No, I would move that with those conditions, that the license be awarded to Sterling Suffolk Racecourse LLC.
Second.
Second.
And discussion on the issue.
Just briefly, since we last took this matter was it a week or 2 weeks ago? 1 week. Had the vote already occurred in East Boston?
Yes.
Yes.
That it has. Thank you.
So, and on the issue of the elephant in the room issue about what happens in the event that Suffolk does not go forward with an application or is not awarded a license, we just basically cross that bridge when we get to it, right?
Yes.
And I do think, not to open up the door to the elephant, but I do think that they're a little bit differently situated than the new entities that are applying, in that you can imagine different business scenarios where it may make sense for them to continue
Right,
racing
but
or not. I mean, we don't need to reach that in order
Right,
to reach the decision on the
But
license.
basically, in all 3 cases, we're just saying yes for now, and we'll see what happens.
Yes.
Yeah. Okay, any other discussion on this motion? All in favor of the motion as posed by Commissioner McHugh, say aye.
Aye.
Opposed? The ayes have it unanimously.
The next application was received from Springfield Gaming and Redevelopment, LLC. That's an application to conduct harness horse racing at an existing facility known as Plain Ridge Racecourse in 2014. Again, the Racing Division did recommend the approval of this application subject to the following conditions. The applicant shall work with the commission to ensure that key racing employees, once defined, are identified and subjected to an appropriate background check. The applicant shall work with the racing division to amend its request for simulcast import and export prior to January 1, 2014. The approval of simulcasting is pending additional review by the racing division. This approval also authorizes the 12-week premium free period elected by the applicant and up to 15 Breeders' Cup races as premium free special events. We do not at this time authorize the use of the Winline as a telephone account wagering system. Just so you know, we have received the materials that we requested from last week, and I believe our Chief Information Officer is going to be doing a site visit at the course tomorrow to do some further due diligence on that. We'll come back to you regarding the approval of the Winline when that is appropriate. Any amendments to existing contracts and agreements or newly executed contracts and agreements with Representative Horseman's Group must be provided to the racing division within 5 business days of execution. And again, the applicant must provide a copy of any temporary operations agreement executed between Our Way Realty and Springfield Gaming and Redevelopment within 5 business days of execution.
I move that we vote to award the license, including the 4 conditions as just stated.
To Springfield Gaming.
Yes, to Springfield Gaming and Redevelopment LLC.
Do I have a second?
Second.
Any discussion?
Same as last one. There, since we last took the matter, there were ongoing discussions relative to a temporary operating agreement. Those, I take, are ongoing
To the best of my knowledge, they're ongoing.
and have not been finalized. So
Correct.
we're in the same position as last time.
Yes.
Any other discussion? All in favor signify with aye.
Aye.
Aye. Nay, opposed nay. The ayes have it unanimously.
The third application received was from an entity, Brockton Racing LLC. This was the application where we discussed a couple of different options based on some of the situational, the unique situational requirements on which the condition was submitted, on which the application was submitted, as well as some inconclusive. We have not yet finished our due diligence on this applicant. We recommend the application of Brockton Racing LLC for live harness racing dates in 2014, and we went with the provision in 128A, Section 2, which talks about approving 1 racing day, and then the ability of the applicant to come back to us with a supplemental application at such time as those conditions are fulfilled, the conditions that they've put on their application. Once those are fulfilled, they can come back to us, and the commission and the racing division can consider a supplemental application.
Do I have a motion?
I move that the recommendation of the Racing Division to award Brockton Racing LLC a license for 1 day in 2014 be approved.
Second.
Any discussion? Everybody's familiar with the strategy and how this came about, and how we discussed the various ways of dealing with this, and they came to think this was the best way to go under all the circumstances. All in favor signify by saying aye.
Aye.
Opposed? The ayes have it unanimously.
Mr. Chairman, I just want to check and to verify that these decisions of the commission will come out in a decisional format once it's proofed and delivered.
I'm sorry?
I understand correctly, these decisions will be reflected in the new decisional format once it's proofed and signed by the commission.
Okay.
Will it be a separate license that actually is issued to the license holders as well, that they can put on the wall so everybody can see it, know it's a legit operation?
I believe that's our plan, yes.
Okay.
And not just that it's a legit operation, but that there's also a statutory requirement for the posting of such license, so we'll
Right.
satisfy that as well. Hence legit. That would conclude 3B. If we're ready to move on to item 3C, which is a request from Plain Ridge Racecourse to amend its live
Excuse me,
racing schedule. Yes.
Director Dernberger, there's a few other, there's a series of things having to do with the Raynham Taunton legal issue with European wagering services. Is that here for a reason?
Good morning, Commissioners. The purpose of having that in your package is to let you know that I have been approached with a claim from the party who authored that letter. That is an alleged contractual dispute between one of the members of Brockton Racing And it is there purely for the commission to be advised that that claim has been made and that request for a hearing in front of the commission has been put out there, but also for the commission to assess whether that has any impact on the granting of a racing license to the Brockton applicant, since the Brockton applicant is an affiliated entity to the entity that's alleged to be involved in that claim.
Well, I probably should have talked about that before the vote rather than after, but it sounds like your reaction, these folks are sort of snidely alleging that we've refused to talk with them or refused to hear this, and none of us, I don't think we even knew about this until just now.
No, we have not refused to grant them a hearing. I have asked the applicant on more than one occasion to address this issue, and I have forwarded these matters on to the applicant. I did ask the applicant to be here today if you had questions regarding how the applicant plans to handle this matter in the future. And also because I wanted to give them an opportunity to respond, and you'll see their responses attached to the letter as well.
Well,
Mr. Carney would like to respond, it sounds like.
Good morning, everyone in the commission. Yes. For the record, my name is George Carney, and that issue that the council just brought up, first of all, is this, that dispute has been going on. That started in 2009. That was the last year we ran live dog racing at the Rainham Dog Track. I never heard a word from them. I've been trying through our attorneys to get them to send us some invoices and to see if we get this resolved. Because we don't, first of all, is this, we don't really know who to pay because there's 4 or 5 different people. There's been 2 law firms involved. Unfortunately, I sent them, without checking with the attorneys back maybe a year and a half or 2 ago, a check for $10,000 with a letter, said, please send us some invoices, excuse me, send us some invoices, and who we were doing business with, because there was an issue raised by the attorneys that represent me, and as far as the thing was concerned, we never heard a word. And then they said they were going to forward the invoices to the attorney. They've never sent one bill to the dog track. The only communication we ever had with them is when they send something to the Gaming Commission and leave it hanging out there, and that's it. We've been trying to get this thing resolved for quite a bit of time. I'm not a deadbeat. I pay my bills, and as far as the thing is concerned, if they can show me what we owe them and who we pay, I'll pay it immediately. Thank you for your time. If there's any questions, I'll be happy to answer them if I can.
Looks like your associate might have something to say.
Well, I don't know what she has to say, but I know what I have to say.
and you just said it.
There's not much, for the record, Commissioners Grace Lee, on behalf of the applicant, there's not much more I can add to that. What I can represent is counsel representing Mr. Carney on this particular matter had in the past reached out to the first law firm and repeatedly kind of tried to follow up on that. So that has been in the works, and General Counsel Blue had informed us, and we've been working with Michael Maurizio, and he has been working on that. So there's not much I can add beyond what Mr. Carney has eloquently stated. Thank you.
Mr. Chairman, just a note, with the approval of a one-day license, the applicant will have to, the licensee will have to come back before the commission in any event, and that will provide enough time to make sure the issue is resolved.
Right.
And if I could just step in, and I just want to, the overarching issue that's presented in this letter from the council in California, we are mindful of the commission's role in regulating simulcast wagering under the Interstate Horse Racing Act. And in fact, I came to you when we looked at the ways we were amending our racing license applications for this year. We didn't make a lot of tweaks to them, but one of the significant tweaks we made was in how the whole simulcast approval process takes place. So we requested a bunch of different information, additional information this year than applicants had previously had to provide. We've hired a chief parimutuel officer. We've been working very closely with her to sort of firm up our process, quite frankly, revise it. We've talked to numerous other jurisdictions. We've assembled best practices, again, in the industry. We've got new forms this year for people to fill out. We are creating electronic files of all of the individual contracts. So I don't want the commission or anyone else reading the record to think that we're not mindful of the statements that are made regarding the commission's role in regulating simulcast wagering under the Interstate Horse Racing Act, as well as the general laws.
That's very helpful.
Yeah, so.
Any other questions, Misa?
No.
Thank you.
Thank you.
Thank you both.
So it sounds like at worst, it's just a run-of-the-mill business dispute and nothing that bears on the vote that we just took. Is that,
I would
Yeah,
agree.
I think the underlying contract is, it's not clear who the contract is with,
Right.
so I'm sure they'll be able to work this out.
right, okay.
The final issue on the racing agenda this morning is a request from Plain Ridge Racecourse to amend its live racing schedule. As we talked about last week, Chapter 123 of the Session Laws of 2013 amends the required number of live racing days and races conducted in order to be authorized to offer simulcast wagering, amending it from 100 days and 900 races to 80 days, 720 races. Plain Ridge Racecourse, as of today, at the end of today, will have conducted 92 racing days, 747 races, and requests to amend its schedule to cease live racing at the end of today's card. They're in conformance with the statute.
Questions or issues? I have a motion.
Do you recommend that we adopt this?
I do recommend, yes, sir,
Okay.
for the reasons outlined in the memo of
Yeah.
last week.
Right.
Simply pursuant to the law, to the amendment of the law, they now can do this. All right. Someone want to, Commissioner, you want to move?
Yep. I move that we approve the recommendation of the Racing Division and allow, and the request made by Plain Ridge Racecourse to shorten the racing season as per the law,
As per the letter of November 4th.
as per the letter of November 4th.
Good, thank you. Second?
Second.
Any other discussion? All in favor signify with aye.
Aye.
Opposed, nay. Motion passes unanimously.
And that would conclude the Racing
Quick.
Division's report. That was a brief
Great.
one.
Thank you.
Thank you.
Thank you, Commissioner.
Thank you, Director.
Thank you.
Ombudsman Ziemba.
Thank you. Thank you, Mr. Chairman and Commissioners. Today, we are here to hear from applicants and communities that have filed petitions to become surrounding communities. We are joined here by the Raynham applicant and the Leominster applicant, and we're also joined by 6 communities, 3 for the Leominster applicant and 3 for the Raynham applicant. So we have a number of items on the agenda today, so let me just give you a little bit of a preview. What I'm anticipating is that we will first hear from the Leominster-related communities, and then we'll hear from the Leominster applicant. Then we will hear from the Raynham communities, and then we'll hear from the Raynham applicant. And then following that, those presentations, we will then get into an involuntary disbursements petition that has been put forward by the city of Fitchburg. I anticipate that it is likely that the city of Fitchburg and the applicant will address a number of the contents that are included in their voluntary disbursements petition in their initial remarks, but they may have some more to say after the initial remarks. And then we have that up for a vote for the commission. As I noted in my memo to you, what we decided was that similar to the way that it's treated in our regulations, that this presentation on voluntary disbursements would primarily be as a result of the presentations and the papers submitted both by the applicant and the potential surrounding community of Fitchburg, but that staff reports, staff reports on all of these matters on surrounding community petitions are hopefully going to be completed by early next week. So to the extent that it is unclear from either the initial presentations by the city of Fitchburg and the applicant or their subsequent presentations specifically on the involuntary disbursement petition, if it's unclear that a designation for an involuntary disbursement is basically an obvious decision. What I'd recommend to the commission is that potentially we could delay that decision for 1 week to next week on the 21st, when we'll be reviewing all of the surrounding community petitions. But we put it to you today in case it is an obvious decision, because there would be value to the city of Fitchburg in being able to utilize their consultant for additional 1 week if we go forward on the involuntary disbursement petition. So in that regard, what I'm going to first do is I will ask the town of Bolton to come up and give a presentation. We have told each of the communities and the applicants that the commission has received their written correspondence, and we'll review that very fully by the time of our decisions on the petitions next week. So they don't need to otherwise repeat what's included in those presentations. But if indeed they have some additional items of emphasis or additional information that they wanted to bring forward to the commission, they could do so. From the town of Bolton, I believe that we have Selectman Larry Delaney and Town Administrator Don Lowe, or?
Mr. Lowe is still in transit. I'm Larry Delaney.
Good morning.
Good morning.
Good morning, Mr. Chairman, members of the commission. The reason that the town of Bolton asked to speak to you with regard to our petition is because of this is such an important issue to the town. Route 117 affects every aspect of life in Bolton. We're a town of 5,000 people, and already 23,000 cars a day go through it. In our petition, we attached a statement from our police chief who noted our police, the volume of calls we have is the equivalent of a town 4 times our size because of the volume of traffic we're already dealing with on Route 117. And we are, the town of Bolton doesn't adjoin Leominster, but the gaming establishment is proposed on the far side of Leominster, and we are actually closer to the gaming establishment than 4 of the 5 surrounding communities which have already reached agreements with the applicant. Now, the applicant says, well, Bolton, you don't understand how the regs work, and it doesn't really matter who we made agreements with. And in fact, we're just going to look through the criteria, and under your regs, Bolton is not severely affected. And that struck me as an odd argument, but it's consistent with this extreme position that Cordish has taken. And they did it in their RFA application, where they named 0 surrounding communities, named no one. And they were then asked, well, is there anyone who's proposed to be a surrounding community you're rejecting? They wouldn't answer that question in their materials. They said, we're negotiating with people. Well, as of the time they filed their application, there had been 0 outreach to the town of Bolton. But right after the election, we wrote them and said, hey, congratulations, we'd like to be considered as a surrounding community. Sent that by certified mail. They received it in Baltimore 4 days before their application. We weren't mentioned at all. And then we didn't hear from them until our town administrator reached out a week later. We didn't hear from them at all. And the first contact with Cordish was the day of your Lancaster hearings. So I think the entity here that doesn't understand the regs is Cordish, because they've done 0 outreach to Bolton. Secondly, when their outreach, so-called outreach, began, the form of the outreach was a form agreement that they have entered with the other towns, which the terms of which they explained to us was, if you sign this agreement, you're a surrounding town. If you don't sign this agreement, we're going to oppose your petition. And we said, well, can't we separate these issues? Can't we just decide that we're a surrounding town, and then we'll work through the good faith negotiations? And Cordish's position was, no, you sign the agreement and you're a surrounding town, otherwise you're not. And I think that's consistent with this extreme position. No one is a surrounding town. That they have picked this unique area of Massachusetts where no town is affected, will be adversely affected by their establishment. And I think that's inconsistent with the legislature's intent. It's inconsistent with your rules. Another extreme position that Cordish has taken was they have minimized traffic going through, coming east on 117 in their traffic analysis. And looking through their traffic impact study, we identified, it's Exhibit G in our petition, I think it's also Figure 12 in their traffic study, or figure 11, excuse me. But what they did, in order to reach the conclusion that only 11% of the traffic headed to Leominster was going to go through Bolton, they have this bizarre graphic which says everyone from Boston, every single person from Boston, every single person from the South Shore is going to go up around Route 2. Now, some folks will do that, and some GPSs will tell you to go that way. But I think if you go through, what people in Bolton know is if you take Route 2 through Concord, you do that once, and then you're going to find other routes. And that I work in Boston. I never would take Route 2 in Concord to get here, even if it's a GPS says that's a mile or 2 miles shorter. So they have grossly underestimated. Excuse me, this is Don Lowe, our town administrator, who actually signed our petition. They've grossly underestimated the volume of traffic. And this is all proprietary data of theirs. And they haven't pushed back. All they've said is, nope, it's 11%. We're not going to explain, and that really we're not really going to get that many people from Boston. But they didn't explain their data. They didn't do an analysis, for example, well, even if Bolton was right and half that inner Boston traffic went out the Pike, the number would only be 13%. They didn't do that because we suspect we're right, and that it's going to be the volume of traffic is going to be 30 or 40% coming on 117. And the map illustrates that as the direct access by a transportation infrastructure is 117 from 495. So in concluding, I think the question to ask Cordish is, if not Bolton, who? Who would be a surrounding community to this project? Because they've said, because we think we're the most affected with the possible exception of Lancaster. And the reason that we say that is every car that comes out of Lancaster has already gone through Bolton. And while Lancaster has some issues related to proximity, Bolton has massive issues related to the traffic slowdowns. And by the time traffic gets to Lancaster, it's flowing smoothly. They have 2 difficult intersections in Lancaster. We have 6 in Bolton. And we are also, every night, we are dealing with essentially a 3-hour delay for a mile west of 117. And that's ignored in their materials. So the question again is, if not Bolton, then who would be a surrounding community under their analysis? Thank you.
Thank you.
All right, thank you very much. The question on the table, I guess, that we will be considering probably on next week is whether or not to judge Bolton as a surrounding community, right?
Right.
Whether or not to deem Bolton as a surrounding community, right?
Right.
As you said, the question is, if not Bolton, who? But that's
Well,
not really the question.
yeah, I was being, I'm sorry, Mr. Chairman, I was being a little rhetorical, but the
understand.
argument that they're making is, Bolton, it's rush hour, only be a couple of cars, or 50 cars a minute, an hour through here, and so they're not going to be significantly affected. And the point I was trying to make is that under that analysis, no town is significantly affected by this establishment.
Okay, and so your conclusion is that you think Bolton ought to be deemed a surrounding community?
Yes.
Thank you.
Great. Next, we'll be joined by Fitchburg.
Did anybody else have any questions?
No, thank you.
Next, we'll be joined by the City of Fitchburg, representing Fitchburg, City Solicitor John Barrett, and William Devereaux, Special Counsel to the City.
Good morning, Mr. Chairman, and members of the commission. I'm John Barrett. I'm the city solicitor for the city of Fitchburg. I had prepared some comments. Our main speaker, however, will probably be Bill Devereaux, and unfortunately he was stuck in traffic. I don't know if it's the same traffic that I was stuck in on Route 2, but he is on his way.
He's actually, I'm Matthew Fair with Pinon Lopes Devereaux and West, special counsel to the city, and Bill is here. He's parking the car and will be here in 5 minutes, so I don't know if you want to wait or take us, take someone else.
We could take Sterling out of turn, if that's okay.
He's here, so I don't want to
That's
I
fine.
can speak if you'd like, but.
No, it's
No, no,
great.
that's fine.
Okay, that's
So-
great, thank you.
Representing Sterling, we have Mr. Stanley Weinberg, outside counsel to the town of Sterling. Thank you, Mr. Weinberg.
Good morning, Mr. Chairman, Commissioners.
Morning.
My name is Stanley Weinberg. I'm an attorney from Shrewsbury, Massachusetts, and I have the privilege of representing the town of Sterling. As you know, Sterling has filed a petition to be designated as a surrounding community, and they've done so in order to protect itself against and provide mitigation for the net detrimental impacts of the proposed slots parlor in the neighboring city of Leominster. Obviously, you have before us the submittal that the town has presented. I'm certainly not going to go through that or reiterate what's in there today. You'll obviously have an opportunity to review that. I'll be glad to answer any questions that you might have on that. I would like, though, to emphasize a few important salient points. First of all, Sterling abuts the town or the city of Leominster, and the proposed facility is less than 1/4 of a mile from the jurisdictional line of the city of Sterling. Sterling's concerned about various potential detrimental impacts as enumerated in the filing. A priority issue is the traffic impacts, which you've already heard from Bolton, and you'll hear that again from other communities as well. There are several roadways, including the Interstate I-90, as well as Route 62, Route 12, Choxer Crossing, and other roadways which will serve as feeders to the facility. Even the numbers submitted by the proponents, traffic analyses, acknowledges that there will be there will be traffic impacts upon roadways in the town of Sterling. The fundamental question is, what is the extent of those impacts? Obviously, the proponent is trying to diminish that and say that they're really de minimis in nature and there will be no detrimental impact. The problem we have is that all the numbers that we have before us are the proponent's numbers. We don't have any objective data and analysis to demonstrate what, in fact, the detrimental impacts of traffic and other issues will, in fact, be. And even the traffic numbers submitted by the proponent don't account for and don't even address what I would suggest to be potentially foreseeable issues and stresses with respect to traffic as a result of future once the facility is fully opened as a destination gaming facility with restaurants, liquor, music venue, and perhaps hotel facilities as well, causing further stresses upon the traffic, public safety, and economic issues in the town of Sterling. So we need an objective analysis of the Cordish numbers and essentially a fair opportunity to determine whether or not to determine what the appropriate mitigation measures should be in order to protect the town of Sterling, the residents of the town of Sterling, from the various detrimental impacts that we see will result. So we are therefore respectfully requesting designation as a surrounding community. And you heard the expression before, if not Bolton, then who? And I would certainly suggest, if not Sterling, a community that abuts the city of Leominster, a community in which roadways will be servicing the facility, is not in fact a surrounding community, then who is? And I suggest again that Sterling certainly is, and I suggest and respectfully request designation as such. I'd be glad to answer any questions you might have.
No questions. Thank you very much.
Thank you very much.
Thank you.
We'll be rejoined by the city of Fitchburg and its representatives.
Morning, Mr. Chairman, members of the commission. My name is William Devereaux. I've addressed the commission previously. To my right is John Barrett, the city solicitor from Fitchburg, and to his right is Matthew Fair, who's also assisted me in this matter. I'm not going to regurgitate the memorandum that we gave to the commission. I think we adequately addressed the factors that are laid out in the statute as to why Fitchburg is a surrounding community. I would submit that it is not only has a case been made, but it's a logical conclusion that Fitchburg is a surrounding community to Leominster and where the proposed gaming facility is going to be. I did read Cordish's memo that apparently was sent to you a day and a half ago. I'm still trying to understand some of the logic of it, but basically, I do want to dispel a couple of notions. One is that we refuse to negotiate with Cordish. That is just not accurate. The mayor did sit with representatives of Cordish, and basically their position was that they're bringing nothing but good things and that the town of Fitchburg should take what they offer. I note that in their memo, they indicate that we shouldn't hold it against them that they have already made community agreements with, I would submit, other towns that have a compelling case that they're surrounding communities, but not as compelling a case as Fitchburg. They don't want you to, I think the words were, use that against them. We're not here to create an adversarial situation at this point, but it frankly is a tacit admission that those are surrounding communities recognized by Cordish. And you can't be a surrounding community if you've agreed to essentially take what they've offered, but not be a surrounding community if you haven't. And in essence, on the one hand, we're not a surrounding community, as I read their memo, because various factors that they've cited, which I submit really don't hold water. But then we are a surrounding community because we're going to get all of these benefits. And I would submit to you that we're not here to say that convenience gaming is a bad thing. It's an entertainment venue. People have an absolute right, adults have a right to choose whether to patronize it or not. But there are going to be some negative consequences to it, despite the fact that Cordish doesn't seem to want to acknowledge that. And those negative consequences have to be weighed by this commission. And I would submit to you that that's the reason that we have the disbursement fund. To say that we haven't rebutted their traffic experts that we haven't obviously had a chance to examine, we don't even know what the foundation of their data is, to say that we haven't rebutted some of the other assertions, frankly, puts the cart before the horse. If we're a surrounding community and we get a disbursement, we can get independent experts that can address those concerns and bring to you intelligent information that you can weigh. And I can tell you that Fitchburg hopes the door is always open. If we can have meaningful discussions with Cordish and reach an agreement, we would like to do that. But in the meantime, we're going to protect the city's interests, and I do hope the commission will protect the city's interest by finding that it is a surrounding community. And then we'll go through the process. We will get information to present to the commission. And if we have to go through the arbitration process, we would be prepared to do that. I don't have anything further unless the commission has some questions.
Commissioners? No questions?
No questions.
Okay. Thank you.
I actually have one for John. Are we going to take the matter of involuntary disbursements at a later time as well?
Yes.
You outlined in your, okay.
Yep,
Because I have
so-
questions about that request.
Yes.
But I'll reserve them for that time.
No, I don't think so.
All right.
Great.
If I might, if we are going to deal with the involuntary disbursements,
Where?
mainly what I was
Later.
going to...
Later.
Later. I'll
Just
just make
like-
comments particularly to that then.
Thank you.
Right.
Thank you.
Thank you.
Thank you.
Thank you.
Joining us from PP Casino Resorts, we have Mr. Joseph Weinberg.
Excuse me while I just get a... got these to
Great, thank you.
hand out so they don't have to record that.
Thanks.
Well, they're setting up the AV here. Let me just start by saying good morning. As you all know, I'm Joe Weinberg, Managing Member for PPE. I thought I'd start a little bit just by an introduction to how we've approached the issue of surrounding communities. Again, there was no precedent for this anywhere in the state, and other than trying to interpret the statutes. We took the approach of looking at our, I'm going to call them neighboring communities, and how could we work with our neighboring communities to try to make the benefits of our project available to our region, and really try to approach this as a project that would benefit the region. From the standpoint of the technical requirements of a surrounding community, which requires that or outlines that your surrounding community, if you meet a number of tests, it's not just have a border that's adjacent, but it really gets more into, is there a significant adverse impact that you're going to have on that community? And we truly believe that we are not going to have a significant adverse impact on any of the communities around us. As you know, the statute also looks at if there are any adverse impacts, how do you weigh that against the positive benefits of the project? And I think that the Commission, the state, the people of Massachusetts who voted for this Gaming Act, if they believed that the net benefits were negative, we probably wouldn't be sitting here today. So what we did was, you see on the map here, we see Leominster in the middle, and then we have 8 communities who we have been contacted by or in touch with regarding what I'll call these cooperation/surrounding community agreements. You can see to the east is Lancaster and Bolton. Lancaster is the only community that actually shares a border with the casino project itself. And in fact, we have entered into a signed surrounding community agreement with Lancaster. We've also entered...
That's a completed agreement?
Completed, and I actually have it to give to John today. We also have 4 other completed agreements with Lunenburg, Townsend, Westminster, and Princeton. And just to address one of the final comments from Bill recently, the statute encouraged these amicable negotiations with neighboring communities. And you have to start and try to put them together as you're able to do it. I think us and any other developer who felt like by being amicable to work out one of these cooperation/surrounding community agreements, that if it was going to be held as a prejudicial evidence that anyone else who is in the same area is entitled to the same status as a surrounding community, we, and I don't think anyone would undertake these types of amicable agreements. Because the idea is to try to create this sphere of cooperation, but if it's going to come back to haunt you, that you've actually had constructive discussions, you've negotiated agreements, but that is going to be prejudicial to you with those who do not want to negotiate in good faith, or you just can't come to agreement. I don't think that's what the statute says. I don't think that's what the intent was, and I think it's impractical if that were the intent, because then you get into a constantly rat in the circle. So our approach has been to try to work with our neighbors, to try to work through the benefits of the project. There has been one consistent concern we have heard from everybody we've dealt with, and that's been traffic. And we believe that the traffic impact on the local roads, and I'm going to get into that in a moment, are going to be negligible. We think most of the traffic is going to come off the state roads and state highways. But the approach we have taken in the agreements that we have executed, the 5 that we have executed, has been, as opposed to us trying to convince you that our traffic studies are correct, and town trying to convince us that their projections are correct. The implication of the traffic, because no one thinks that traffic is going to cause level of service impacts on the local roads. The main issue has been over the public safety costs, that if there are more accidents or more DUIs, a lot of the towns have limited public safety officials, and so we're concerned about overtime costs for police or fire.
Excuse me, that's, from what I've picked up, that the biggest issue was actually the flow of traffic and how much that was going to affect people's lives, not only. It also included the demand for public safety services, but I would have said, just from what I've heard, that was secondary.
Well, I will tell you, in our discussions, the primary, Bolton may be the only exception where, but even in those discussions, and I want to take you through it because you have to have a flavor of the issues that are being discussed. The primary concern has been the cost of police and fire responding to accidents caused by there being increased traffic. Because and I will show you in a second as we go through the local roads, the increase in traffic we're having on local roads doesn't exceed 2%. 117 is the exception, but the other local roads that go through Sterling or Fitchburg or Westminster, or Princeton, there's a negligible impact on the flow of traffic or the increase in traffic. So the way that we dealt with it in the 5 agreements that we've done was we've said that we will pay for any responses, actual costs of any response that your fire or police have to our customers. And some it's left, they bill us for, for whatever they believe legitimately is being caused by, additional events caused by customers of the casino. In other instances, we've tried to do a formula, which basically looks at the number of traffic incidents on the road, it's all public data, for the 12 months prior to the opening of the facility, and then the 12 months after the casino opens. And while, from a practical standpoint, we would not be responsible for, the causation for all of that, because there's got to be something else going on in the region, we've agreed in those incidences that we would, whatever it is we'll take responsibility for any increase in accidents on the road based on that formulaic comparison. And that's allowed to get out of the cycle of having to argue over, is our traffic report correct, or do you need to go do lots of other studies? Because you go spend money on lots of other studies, it's just more projections on what it's going to be. So we've, so in those 5 agreements that we've done, where it's a very rational look at, okay, how do you make sure that it's you can't argue with it, you look at actual data. Jeff, if you can, by the way, before we leave this shows a 1, 3, and 5 mile circumference around the gaming site. As you can see, the only communities that are within 5 miles, for the most part, of the casino, not of Leominster, but of the casino, is Lancaster and Sterling. There's a little bit of Lunenburg and a small bit of Bolton. If you get to the next.
Why did you pick 1, 3, and 5 miles?
Just to show a range of proximity, because really once you, and I'm going to try to get into this as we go through the additional upcoming slides. Clearly, as you radiate out from the facility, the potential impacts diminish. Our traffic does not have a lot of peak flow to it. You know, we're a 24-hour operation. If anything, our traffic is countercyclical to the normal midweek rush hour periods. So, you know, morning and afternoon drive times are, you know, low peak periods for the casino traffic. So you really have traffic being dispersed along lots of different roads and coming at a lot of different times, and mainly off-peak periods. So clearly, as you radiate out from the facility, it's hard to argue that there's lots of measurable impacts. This slide just shows Fitchburg, you know, which I'll get into addressing the individual communities in a second. Jeff, you keep going. This shows the road network. You'll be able to see it easier, I think, from the handout I gave you, and the type of traffic that we project we'll be putting on the local roads. As you'll see, whether it's 13 coming down through Townsend and Lunenburg, or 12 and 31, 140, 12 and 62 through Sterling, the amount of traffic generated by the facility is, you know, less than 1%, 1-2%. It's very negligible traffic coming through the local arteries. The projection that most of the traffic will come down 92 and then 117. 190, I'm sorry. This next slide shows...
Excuse me one sec.
Sure.
I see that it looks like 117 says 11%. Where are the percents? Oh, there, and 2 was 37%. Okay,
Yeah, I'm gonna make it easier
right,
for you to
fine,
see
okay.
that in a second. So if you go to the next slide, this is a trip route utilization overview. In looking at, and this kind of addresses the comment from the selectman from Bolton, when you look at what routes people are going to use, our traffic people looked at the you know, the most likely, quickest routes to the casino, and you know, most of our traffic, given, you know, we have to look at it in terms of what's going to be the full build out of the gaming business in Massachusetts. And when you know there's going to be a facility in the Boston area, one in the south side and one to the west, you know, a predominant amount of our traffic is going to come from the kind of the mid part of the Beltway and north, and then north and south of the, you know, on 190. And so that's how we got to our trip utilization. And so we show kind of where we believe people are coming from and what route they'll take from each market. If you go to the next. I think it's also helpful in terms of looking at, will this facility create any kind of material significant adverse impacts on any of the surrounding communities. The location that we're building in is a commercially zoned area. It has been identified both by Leominster and the Wachusett Regional Planning Commission for intense commercial development. So whether it's the casino or it's other types of developments, this area has already been slated for development and is targeted by the region. This slide compares the traffic that the facility will generate in terms of trip generation to and this looks at midweek peak hour, and it looks at a number of different comparisons. The first the NED mixed-use development. There had originally been several years ago, a regional mall plan for this location. So this identifies what that would have generated in terms of peak traffic. There's an existing Walmart across the street from the proposed gaming site, and their peak traffic is about double what the gaming facility is projected to have. We've also provided comparisons to a typical strip shopping center, 160,000 square feet, a supermarket, and Lowe's, which is also in the area of the casino. So when you compare it to other commercial uses that are targeted for this area, the gaming facility does not generate excessive peak traffic. Move on, Jeff. This is probably easier to look at in terms of, this looks at the trip distribution on the local roads. So what percentage of the site trips are coming through each community and each of the local roads. And you can see, with the exception of Lancaster and Bolton, that all the other communities have less than 2% of the trips coming through their communities. And you can also see why we took the approach of trying to just treat everybody in a similar framework, because really the traffic that's coming through the local roads are, give or take, relatively the same through each of these communities.
Well, not quite.
What's that?
With the exception.
I said with the exception of Lancaster and Bolton.
Yeah.
Yes. And in those instances, we're looking at about 11% of the local trips coming through those communities.
Jeff.
And this looks at the daily increase in traffic versus current condition through each of these communities. And similar to the prior slide, it shows you that the increases are also in the 2% range, with the exception of Lancaster. We'll see about an 8% increase in traffic on 117, and Bolton will see a increase of about 4%. Now, the reason why the increase, I'm sorry?
Maybe you were...
Yeah, the reason why the increase in Bolton is less than Lancaster is that they have, this is increase in traffic, so they have a much higher volume of traffic today coming through Bolton than Lancaster. So the additional, again, actually, if you go to the next slide, Jeff, it'll...
Oh, I see. This is the percentage over the existing. I got it.
Right.
Okay.
So you have to compare to what's the existing state and what's the impact of the incremental traffic that we're adding to the roads. The other thing that needs to be kept in mind is that, for instance, through the MEPA process, one of the things we're looking at is the intersection, and this was required under our E&F scoping, was looking at the intersection of 495 and 117. So issues of traffic improvements that are required under MEPA, if there are any, I mean, that's something that will be looked at as part of our environmental impact review. That's something we're responsible for outside of the surrounding community agreement. So if there are traffic improvements that are needed to be made under the MEPA process, we're required to make that. So that's not an issue in terms of the road improvements under the MEPA process under this surrounding community agreement. Jeff? So moving on from traffic for a moment. Some of the other items that have been outlined in some of the petitions by the communities for surrounding community designation have implied that somehow we will put some stress on the infrastructure of these towns, and that's simply not true. All of our utility infrastructure, water, sewer, has been provided by the City of Leominster. We will be improving the drainage in the area. Right now, the area that we're at actually has a lack of stormwater and drainage control. So we're going to be putting in state-of-the-art systems and really improving the drainage issues in the area. Electricity and gas are coming from the national grid provider, and there's plenty of capacity. There had been a statement in the Sterling petition that we were somehow impacting their aquifer. We've provided a letter from the Department of Public Works from the city of Leominster stating that this area is being served today solely from the capacity of the city of Leominster. It's not impacting the aquifers of Sterling. From a traffic standpoint, this is construction traffic. We will mandate that our construction activities happen on the major roads, unless, of course, the contractor is located in one of these local communities, which is one of the things that we're trying to do, which is to hire as many local people as possible. Obviously, noise from construction, we're in a commercial industrial area, and so there's no overflow or impact from construction noise to any of these communities. From a traffic standpoint, there is no road, including 117, where we are diminishing the level of service of the road. 190, which is our major artery that we're off of, is way underutilized at this point. I think it's 30%. I mean, it's only using about 30% of its capacity. So we have that infrastructure available to us. From a public safety standpoint, we're building a police substation as part of the facility for the Leominster Police, and that's in addition to the state police mass gaming presence on the site.
I was going to ask about clarification. I've heard
Yes.
concerns. So what you're committed to is that you will build enough to provide a substation in addition to that space which is required for the Massachusetts State Police and the gaming.
Absolutely. If anything, we undersold the amount of regulatory and state and local presence. But to clarify, absolutely, we'll have both what we're required to do under statute for the Gaming Commission and State Police, as well as a new substation for the City of Leominster Police Force. That's a written obligation under our host agreement. And then another item that is included in some of the petitions is a concern over the social aspects regarding problem gaming. And as you all know, the facilities will be paying a lot of money, and a big portion of the tax goes towards addressing problem gaming issues. In fact, the state will be spending a disproportionate percentage of what's being spent in the entire nation. So if anything, we believe that there will be more resources available for addressing these social issues than exist today. Of course, we're surrounded by states and gaming facilities, and so we just believe that given the size of our facility, and that if anything, collectively between the facility operators and the state, will be bringing more resources to this issue. And in fact, the state has 12 state-funded programs to address problem gaming, and one of those is located in the city of Fitchburg. And so the state is already funding those programs in the region.
But before we leave this slide, what do you mean by the first one, no level of service increase on any local or state road?
Roads are given letter designations A, B, C, D, and F, right? Skips E, which indicates at what level of operation is at, A being the best level of operation, F obviously being failing. And so typically you need to to move from one letter designation down in level of service, I think the typical rule of thumb is Rick, about 10%, a 10% increase in the traffic, and not only that, but that causes it to then not operate properly. But typically 10% is the threshold. And so there's no road that we are impacting to that degree, that we are changing how the state would designate the level of service on those roads.
You have an 11% increase on 117.
It's not an 11% increase on 117, it's 11.
8%, right?
Right.
No.
That's over.
I'm sorry.
11%.
That was 11% of the trips on the local, yeah.
11% of the trips.
Right.
Generated trips, right?
Right.
Which nets to an 8% increase over its present
That's
volume.
right. That's right. That's right.
8% in Lancaster and
Right.
4% in Bolton.
So I guess I'm thinking, I hear you, but I'm thinking, you know, you add a drop of water to a full cup and it overflows. And so that's not an exact analogy, but the impact on an already overstressed road may only be a slight increase,
Right.
but that slight increase may have
If you're already at a
hugely
peak, right.
detrimental.
Right.
Well, and that's why we look at the peak, we look at the peak traffic numbers. So for instance, in the Bolton-Lancaster area, we project about 54 trips per hour during the peak, what's it, 4 to 7? 5 to 6. So during the peak rush hour traffic, we project about 54 trips during that area. Again, our traffic is typically countercyclical to those rush hour traffic. So we're talking about adding, you know, less than 1 car a minute. Yeah, a minute
Right.
to the
Right.
to the traffic. So it's not. So during those stress periods, it really is not a terribly significant increase in the traffic on the road.
I hear you.
Obviously, we're not competent to make these decisions by ourselves, and so this debate will, you know, the experts will talk about and we'll listen. The issue before us is whether or not certain towns should be deemed surrounding communities. And it sounds to me like your position, at least in 2 or 3 of the cases, at least in 2 of the cases, is not that they shouldn't be surrounding communities, but that you want to speak to the issue of the nature of the surrounding community agreement. Because if Townsend is a surrounding community, it seems like pretty logical that Lancaster or Bolton is going to be a surrounding community.
Well, again, so let me address that. There is a difference between entering into a cooperative, amicable agreement with a town under the statute, which is one of the ways a community can be designated a surrounding community, versus where an amicable agreement cannot be reached. Then you have to go to, okay, there's a test set down, and there are certain parameters set down under the statute. And we do not believe that any of the petitioning jurisdictions meet the test of a significant adverse impact from the facility. And if we go to the next slide, Jeff, we cannot ignore, because it's a balancing act of the positives and negatives, if any. When you look at the positive impacts of the facility in terms of jobs, we have over 1,200 jobs, construction, permanent, direct, and equal number of indirect. We have a $30 million annual payroll. We have over $20 million in goods and services that we're buying in the area on an annual basis. We have tremendous support from all the area chambers of commerce, businesses, attractions, universities, community colleges, workforce development, the venues in the area. We have the program with the University of Massachusetts, where we're funding between $1 million and $1.5 million a year to grow new businesses in the medical device industry and to get those companies to manufacture in the North Central area. Will be a major charitable giver in the area. So there's tremendous positive impact that the communities around us will receive the benefit of, and we want them to, and that's why we're all doing this. But when it comes to do they meet, the petitioning communities meet the test of a surrounding community under the statute, what we've done in an amicable way with any other community is really not relevant.
So your
to the
position on
test.
Lancaster is that they don't actually qualify as a surrounding community, but you've gratuitously done a surrounding community agreement with them because of the way in which they've negotiated with you.
We don't believe that we have significant adverse impacts on Lancaster, but clearly they actually have a border that touches where we are. So that was one that we would say was very important to come to terms with. We would say after Lancaster, though, in terms of we want to reach amicable agreements with all the communities we showed up there. But when we believe that the terms are not acceptable to us in terms of has been discussed. I mean, for instance, take Bolton, for example. We have a final agreement that was presented to their Board of Selectmen, I can't remember if it was last night or 2 nights ago. So, we have worked hard to try to reach.
And what happened with that?
And then they rejected it 2-1.
So one of the selectmen thought it was okay and 2 thought it wasn't.
Yes. And if you read the comments, I mean, just so you have a flavor of the difficult position everybody is in here. When you read the comments that were in the paper that I read, I don't know if it was this morning, but I just saw the article this morning. The comments coming out of the selectmen, who I never met with, by the way, the gentleman who made the presentation never, he made a lot of comments about it, but I never met with him. We met with the town administrator and we worked through an agreement. But the comments from the selectmen were not, the agreement doesn't work because it doesn't address this specific impact that we have. The comments are, we can do a better deal, or we should get what Leominster got, or we should get a larger piece of what Leominster received, or this facility's going to make a lot of money, they ought to pay us more. So those are the types of impressions out there that some of these boards have. And I'm just quoting what was in the paper. I wasn't there, so I can't say whether the quotes are accurate or not, but that's what was reported. And that's not what the intent of this process was. It was to identify impacts to the extent they are identifiable, and to try to address it. And that's what we've done. So, for instance, just to give you a sense of the agreement with Bolton, and by the way, the agreement we have with all of these communities have on the issue of traffic and the costs of that traffic, it self-modulates. So the community gets compensated based on the actual impacts they have. So there's a misunderstanding and I think there's a misunderstanding in Bolton, that somehow they should get more than the other guy got. Because if they have more traffic incidents, the way we had approached it, then they get more. Because it's based on that actual experience. But again, to answer your question, we do not believe they meet the test or that any of the other petitioning communities meet the test of a surrounding community. And we think the fact that we've signed and we've done a good job of trying to bring other communities into the fold and have negotiated successfully 5 agreements, to hold that against us seems to be anathema to the whole intent of the process.
So if I understand your position, just to make sure I do understand it, apart perhaps from Lancaster, none of the communities is a surrounding community within the meaning of the statute and the regs. But you've negotiated agreements with them so you don't get to the factor
Exactly.
test. And nobody should hold against you the fact that, or use as a precedent, the fact that you entered into a surrounding community agreement with a community that's not really a surrounding community.
You said it much better than I did.
Well, no.
Yes,
I just
I
want to
agree.
make sure I understand.
Yes, you did, Judge.
No, that's a very fair summation. So I'm happy to answer any questions.
What are the essential terms of the deal with Lancaster, the agreement with
If,
Lancaster?
you go
Same
to the
same
next-
as the one that you put up on
I'll
the
take,
board?
I'll take you through. So this is not the Lancaster agreement, but I'll tell you
What are they, the same?
it's Lancaster's slightly different.
Okay, so I'm asking about Lancaster, yeah.
I'm sorry?
So I'm asking about
So
Lancaster.
on Lancaster, there's an annual community impact fee payment of $35,000 per year. We agreed to pay them up to $200,000 to do road design on an intersection that they believe they're having issues with today. So we agreed to fund those the road design work. Feeling that any improvement there will benefit from as well. And then it has these additional provisions. So there's and this is true of the 5 that we have signed. There's a public safety response cost reimbursement, which is we reimburse the actual cost for police and fire responses caused by our facility. We have created what we call a surrounding community benefit payment, which is a rising scale of a percentage of our gaming revenues over a breakpoint, which starts at 0.25% and rises to 1%. So the idea was that, we achieve great results in the facility, that the communities will share in the benefits of that.
0.25 to 1 is for each of the communities that signed this, or this is a pool that would go to the?
It's a pool that would be shared by those communities that enter into.
And what's the break point in gross payment?
First break point is $200 million. Cooperation in seeking funds from the Community Impact Fund from the state, local hiring preferences, local vendor preferences for the facility. Of course, our ongoing commitment for running a responsible gaming program at the facility, participation in regional marketing and tourism and cross-marketing programs with both the communities and their businesses. And then we also provide for the reimbursement of the town's costs in negotiating the agreement with us.
Do the local hiring and the local vendor preference dilute anything that was in your agreement with the city of Leominster?
It's all subject to the host agreement. So, we believe that the people we'll be hiring and the businesses that we will be doing business with, that there's not sufficient capacity in Leominster to satisfy all our needs. So we believe that there's a major opportunity for the whole area.
Go ahead. Is there a reopener of some sort in the Lancaster deal? Take, for example, if your estimation that the 8% increase doesn't move it from one category down to another, if it did, if it were 15% instead, is there any kind of a reopener?
There is not a reopener. One of the reasons for the participation in the Community Benefit Fund was, there's maybe some relationship between our revenues that we're doing and the type of traffic we're generating, so that would provide additional compensation to the communities. And then, of course, the Community Impact Fund that's being created under the gaming tax to the state. That's really the very reason for the use of those impact funds, or the things that today we can't sit here and say that's going to be an issue, that fund is to address needs in the future for the
Well, the way
communities.
we've characterized that fund is that will be available for unanticipated or unanticipatable.
Right.
And, the fact that your 8% number, by your own discretion, the number of public safety incidents, you can claim one thing, somebody can claim another, nobody's going to really know until it's over, so you've put in a sliding scale, which seems eminently fair.
Right.
You might very well take the same approach towards traffic.
I wanted to ask about the MIPA process that you will be required to do if you follow through. Can you expound a little bit on what those improvements may look like currently in that intersection or others?
Well, under the MIPA process, we filed our ENF filing, and part of that process is then there's a scoping in terms of anything else the state wants us to look at. And that's also instructive on the whole issue of the surrounding community agreements, because MIPA did not require us to look at any roads in Sterling, in Fitchburg, or any of these communities. There was one intersection which they wanted us to look at, which the state is already looking at, which is the intersection of 495 and 117. And it's really part of a potential revenue share in whatever improvements, if it's anticipated that we're going to cause, and this will come out during our EIR, but to the extent that we're exacerbating the problem there, then there would be we would be required to share in the costs with other, the state and other users and any improvements at that intersection.
Right, so there.
I'm my traffic consultant, just to make sure I'm being accurate. And by the way, when the Walmart was built in the same area, there was no requirement to look at any roads by MIPA in Fitchburg or in Sterling, because it wasn't anticipated that there would be any exacerbation of problems with those roads. So that's also something that's very instructive in terms of the validity of our traffic projections.
Anybody else?
Thank you.
Thank you.
Thank you, Mr. Chairman. Now we'll move on, unless the commission wants to take a break.
Well, and just one thing, just to be sure that I'm clear, but I think also everybody watching. So the process here is that we, with your leadership, will get our own external experts to look at these assumptions and assertions and claims and counterclaims and so forth, and will try to advise us as to what they think is the net negative consequence, net material negative consequence, and that we will then take that under advisement, talk about it probably, and come to our own conclusion as to this threshold issue of should a community be deemed a surrounding community or not.
That's correct.
That's right? Okay.
And we'll do that at our next meeting.
That's correct.
Right.
I'd certainly hope that the numbers would be reduced to where they are now, but I think we're
From
prepared.
where they are now.
From,
Yeah, reduced from where they are now, yeah.
From-
Smaller number.
I wish we had smaller numbers going into this analysis for next
Right.
Thursday.
I hope you're right.
Right, yeah, we all do.
We'll work on
This
that.
is obvious, John, but, this is stuff where we're going to have a tough time. I mean, we have no real way anything to do but rely on experts, and if there are dueling experts, I'm not exactly sure how we're going to resolve that, but unfortunately, we're going to need to see that early enough in the game that we can somehow, if there are continuing material problems and counterclaims, to try to figure that out. I'm not quite sure how we do that, but we're going to need enough time to give that a fair look.
Right. And, from the beginning of this process, we had always counseled numerous entities that to the degree that we could have that outside group providing either an affirmation of numbers or questioning those numbers, it certainly makes the process going into these commission reviews a lot more understandable and manageable.
Right.
But we're now in a situation of trying to look at those numbers ourselves and make determinations based on what has been submitted.
Right.
Do the RPAs have any information that they can add to this mix?
Yeah, so we have RPA reviews for the Rainham application. We don't have a RPA review for the Leominster application, but as part of our process, we're going to contact the RPAs just to see if there's been any studies that we're not aware of as well.
There must have, for that big development, that was the mixed-use development on that same site, there must have been a lot of prior work.
That's right.
Yeah. For what apparently is a much bigger facility in terms of its impact.
That's right.
Okay. What's next? Yeah, let's do. It's 11 o'clock. Let's maybe come back at 11:15.
Great.
I'm pleased to see that our representatives of applicants and surrounding communities are talking. And if they want to keep talking and come to conclusions, we can always postpone this meeting. All right, we are reconvening the 90th session. It's about 11:15. Ombudsman Ziemba.
Thank you, Mr. Chairman. So we will now be joined by representatives of the towns that have submitted petitions relative to the Rainham facility. First up, we have a representative from the town of Bridgewater, Mr. Dutton, town manager.
Thank you. Good morning, members.
Good morning.
Good morning. Good morning.
My name is Michael Dutton. I am the town manager of the town of Bridgewater, and thank you for this opportunity to testify on the town of Bridgewater's petition to be named a surrounding community. For reasons set forth in the petition we filed on October 31st, we urge the commission to find that the Bridgewater will experience significant impacts due to the operation of the facility. The applicant has already designated every other town abutting Rainham a surrounding community, but not the one with the second longest common border in the shared school district. My testimony today is short. We are adding, that always scores points. We are adding information to our prior petition as follows. Number one, an analysis of the applicant's nearby community impact report dated September 2013 finds two critical flaws. First, the applicant contends that the site is located approximately 1 mile from the Bridgewater line. That's correct. But over 2 miles by road via routes 138 and 106. This ignores the most direct route, which is Route 138 south to Elm Street in Rainham to Route 104 in Bridgewater, which is a primary east-west roadway which transects most of Bridgewater. Similarly, the study makes no reference to travel over Route 104 westbound to Route 138 north as a means of accessing the facility, the proposed facility. Number two, the applicant refers to the report issued by the Old Colony Planning Council, the regional planning organization, which fails to find any significant impact to Bridgewater. This report simply is a review of the applicant's nearby community study, which we find flawed and does not analyze any data or independently generated reports. In fact, the OCPC report itself suggests the applicant should expand its traffic study area to include Route 106 and Route 104 through Bridgewater, because it believes that the local roadways will be significantly impacted. Also in 2012, Mass DOT commissioned an OCPC study specifically to review Route 104 and Bridgewater for bottlenecks and to make recommendations for roadway improvements. We clearly already have a highly congested roadway which will be impacted by additional east-west traffic generated by the slots facility. Number three, an increase in traffic on routes 24 and 495, as the applicant concedes, will generate additional emergency calls for Bridgewater as the first responder. Since 2006, our fire department has responded to almost 500 calls on routes 24 and 495. Since 2006, our police department has responded to over 300 calls to the most westerly part of Route 104. Since 2006, our fire department has responded to almost 100 calls for mutual aid to Rainham, with whom we have a mutual aid agreement. An increase in traffic to and from the applicant's proposed facility will require additional resources from the town of Bridgewater. Number 4, the town of Bridgewater and the town of Rainham share a regional school district. A slots facility could be the single most important impact to Bridgewater for 2 reasons. One, a slots employee with children moving to the town of Bridgewater, where homes are generally less expensive than Rainham, will increase our assessment. That's the simple calculation. Second, the host community agreement, which has been approved by the voters in Rainham, will add $1 million in unrestricted revenue to the town of Rainham. Added to the expected increase in property tax value, Rainham could conceivably have an additional $2 million a year to devote to the regional school district. While there's certainly nothing wrong with devoting resources to education, we are concerned that the new and sudden supply of unrestricted revenue will place Bridgewater at a distinct disadvantage, including the possibility that the district would in fact break apart. We do not believe it was the intent of the Gaming Act to put communities in this position. In fact, we do not believe the issue of shared regional school districts was ever contemplated during the Act's drafting. However, it is the undeniable consequence which could be addressed by a surrounding community agreement. I must acknowledge to the Commission that the applicant has been receptive to discussing a nearby community agreement and has reached out to Bridgewater on a number of occasions, and we've had a number of sessions with them, albeit brief. And we are appreciative of these overtures, but we are firmly convinced that the residents of Bridgewater are more protected from any future impacts by being designated a surrounding community by the applicant or the Gaming Commission. As I mentioned earlier, all the other abutting communities have been designated, and we are perplexed why we, the community that bears 60% of the cost of the regional school district we share with the host community, why we would not be among those designated towns. So I thank you very much for your time and your consideration and the time you put into what's obviously a time-consuming and difficult job. I don't envy the commission at all.
Thank you.
Thank you, and I'm happy to answer any questions.
Run the school district by me again. Why might first of all, is there something in the host community agreement with Rainham that specifies money going to the consolidated school district?
No, quite the opposite. There's unrestricted, a $1 million unrestricted payment to the town of Rainham that's included in the host agreement. Our feeling is that that money, any additional, what I call unrestricted money, is going into the host community. More power to the host communities, but it'll put increasing pressure on the our town, Bridgewater, who's a member of the regional school district, the 2-town regional school district. It'll put more pressure on our budget to match the available money that Rainham has to spend on their education.
How does that work? Are you forced on a pro rata basis to match all the money they put up?
Not necessarily forced on a pro rata basis, but certainly if the school committee votes a budget that is much larger than the current budget, primarily because Rainham can afford to pay that extra assessment, it'll put pressure on Bridgewater to try to match and try to afford the additional assessment that we would see.
Are you paying equal amounts now?
It's not exactly equal. I won't try to explain the educational funding formula, because that would be a disaster.
No,
but we roughly 60% of the regional budget is what we pay. Rainham pays roughly 40%. And that is in turn about 60% of our total budget.
Sorry, Bridgewater pays what percent of the regional budget?
About 60%.
And what is the makeup of the school committee?
Makeup of the school committee is roughly equal members from Bridgewater and Rainham. They're voted, I believe, at large.
And what's the student population percentage?
Percentage split is roughly 60-40.
And this is a district regional at the high school level only, correct?
The district is regional, entire region, all
Entire
the
region?
schools, K
All schools?
through 12, correct.
But this dynamic about breaking apart has been going on in that region for a while. It's not new.
It's not a new concept. Our fear is that this could be the impetus to actually break that apart. The financial pressure on Bridgewater and more financial independence in Rainham could force the district to fall apart.
Well, that's a creative approach, which is not to pass judgment at all on the pros or cons of it. Any other questions?
No.
Thank you
very much.
Thank you.
Next, we're joined by Jonathan Silverstein, representing the town of Lakeville.
The ubiquitous.
I've been
And
called many
healthier.
things, never ubiquitous, Mr. Chairman. Good morning once again, Jonathan Silverstein for the town of Lakeville today. I received a call last night from the town asking me to represent its interests here today. So forgive me if I don't have a prepared presentation on the town's behalf. I want to begin by saying that although Lakeville is not an abutter to Rainham, it misses abutting Rainham by not many feet at all to the southeast. And there are a number of concerns that the town has with respect both to major arteries, 495, 140, 44, as well as a number of more local roads. As well as you heard the Bridgewater town manager mention property values. Lakeville as well has lower property values than Rainham and has concerns about housing pressures there and impact on schools. I believe it was November 1st that Lakeville received a draft neighboring community agreement from the applicant, and last week, for the first time, they had an opportunity to sit down with the applicant. Of course, the town was not included in the applicant's impact study and has not received any any consultant funding to conduct impact analyses of its own. In its opposition to the town's submission, the applicant noted that SERPID, the RPA, had not identified any impacts on Lakeville. Again, I'll note that SERPID was only peer reviewing what the applicant did, which did not address Lakeville. And I'll also just read from you a short excerpt from an email that the town received from SERPID, and this was on November 1st. This was from SERPID to the town. Because the MIPA studies are not complete for the proposed facility, there are limitations to this analysis, and we intend to update the work as more information becomes available. But given the rapidly moving time schedule, something I've spoken in the past to the commission about, we felt it was important to provide you what we have done to date. So it's certainly, since they were only peer reviewing what the applicant had done, which did not address Lakeville, and SERPID explicitly stated, hey, this isn't really a very comprehensive study. Lakeville continues to have concerns, and given the timelines, given the lack of impact consultant funding, Lakeville's concerns are primarily about the unforeseen impacts or the unknowable impacts at this point, not because they are truly unknowable, but because there hasn't been any study of those impacts on Lakeville. So that brings us to where we are today, with Lakeville just wanting to protect its interests by getting its petition into the commission prior to the deadline, which it did. I believe, and Ms. Lee, when she speaks on behalf of the applicant, can correct me if I'm wrong, I believe it's very likely we'll be able to reach agreement with the applicant before the commission has to take this up again next Thursday. There has, as has been noted, what the applicant is terming a nearby community agreement proposed to the town. And there may be a couple minor changes that need to be made to that. The problem has been that since it was first proposed to the town simply hasn't had a meeting of its Board of Selectmen, which is the contracting authority, to be able to review that. They have that meeting coming up on Monday. I'm hopeful that I'll be able to report to Mr. Ziemba if not on Tuesday, if there are some other changes that the board needs to make, that I'll be able to work quickly with Ms. Lee and the applicant to make those changes, and then I'll be able to report before your meeting next Thursday that the town has reached agreement. But those are the primary concerns of the town. I'll be happy to address any other concerns or questions that the commission may have.
Anybody?
Sounds like you're on the right track.
Thank you.
Thanks so much.
Thanks.
Now we'll be joined by the town of Rehoboth, Mr. Jeff Ritter, Town Administrator.
Good morning.
Good morning.
Good morning.
I'll break the record for the shortest presentation today. The one and only reason that we're before you today is that, as you may or may not know, the town of Rehoboth is located approximately 10 miles from the site. However, the most important consideration is that the town of Rehoboth has Route 44 that goes directly through the center of the community. And to that end, what we're trying to do is that we're trying to impress upon the commission that Rehoboth is going to be impacted in our public safety realm, in our ability to respond to police, fire, and ambulance. So that's primarily our statement. I wish that you would give us consideration, and we look forward to hearing from you.
Are there discussions going on with the applicant?
We have had discussions with the applicant, and we haven't come to any conclusions as of yet.
Anybody else?
No.
Thank you.
You did set the record.
You did set the
Thank
record. The
And
records are meant to be broken. Don't forget that, everybody else out there.
and the Raynham Park LLC applicant, if they could come forward, Ms. Grace Lee, Mr. Tom Bonner.
Good morning, Commissioners. For the record, there's actually three of us. Grace Lee, for the applicant. I have with me General Counsel for Greenwood Entertainment and Racing, Tom Bonner. And then with me also is Tom Carney, part of the Carney Group. I'm going to actually hand it over to Mr. Bonner. He's been working with Tom and I and reaching out to all the communities, and he'll be able to give you... I'm sorry? Okay.
Question.
So if there's no questions right now, I'm going to have Mr. Bonner give you an update on what we've done and how we've approached this.
Thank you, Grace. Good morning, Mr. Chairman. Good morning, Commissioners.
Good morning.
I am a big fan of brief presentations, but Mr. Ritter set the bar extremely high. I don't think I can match his, but we will be brief. One of the things that I'd like to emphasize to the Commission is that we understand the significance of this process. We've addressed it as a collaborative process. We've included the communities in our meetings that we've had. One of the reasons that I think we've been able to demonstrate our interest in and concern for this project is the participation of the Carney family in our project. These neighboring towns know the Carney family. They know the operation. They know what the Carney family and businesses have meant over the years, and I think that there's a certain level of comfort that comes from dealing with the known entity and quantity. So we're glad that they've been able to be a part of the process. Big picture, we have 11 towns with whom we have had various communications. We have had one meeting with some towns. We have had 4 meetings with some towns. I have a meeting at 2 o'clock today with Grace and Tom Carney to meet with another town. So we've devoted our full effort to this once we got the October 4 application behind us. We've designated 4 towns to date of the 11, Easton, Taunton, West Bridgewater, and we just designated Middleborough on Monday. We have an executed surrounding community agreement with Taunton. That leaves 5 petitioners. Middleborough had petitioned you for recognition, but in the interim, we did recognize them. So there's 5 towns that have petitioned the commission for recognition. They're Berkeley, Dighton, Bridgewater, Rehoboth, and Lakeville. You heard from Rehoboth, Bridgewater, and Lakeville today. You know the status from the comments that were made today. With respect to Berkeley, we have been in detailed discussions about the possibility of Berkeley executing a nearby community agreement as distinguished from a surrounding community agreement. I'm optimistic that we'll be able to report next week that we've reached an agreement with them. So if we're successful with Berkeley and Lakeville, as was just indicated, we'll knock another 2 off the list. So the point is we're working hard, we're making progress. That covers 9. The other 2 towns I haven't addressed, Norton and Stoughton. Stoughton did not petition for surrounding community status because we had, prior to the end date, signed a nearby community agreement with Stoughton. So they're off your radar screen, not to be worried about. The only other town with which we've had communication, but no agreement and no petition to you, is the town of Norton. They haven't been back in touch with us. They hadn't they had not indicated any interest in meeting with us, so I have nothing to report with respect to Norton. So the summary is there are 9 towns who are either designated or have petitioned for designation. We have 1 agreement signed with 1. We hope we're going to have agreements with 2 or 3 others, so we're whittling down the list. Be happy to answer any questions that you may have. That's the summary of where we are. We continue to work on it, and knowing your schedule, although November 21 next week is an important date for designation, we then have another 30 days to try to get these deals done in whatever form these towns may present themselves following your actions next week.
If I could just...
Excuse me, the accessorizing touch with the pen is a nice one. Say again where Rehoboth is, the status of Rehoboth.
With Rehoboth, we have met with Rehoboth and have discussed and submitted to them a proposed nearby community agreement with Rehoboth.
Which addresses this traffic on 44 issue?
Yes, based on discussions we'd had with Mr. Ritter, he had identified that same concern when we met, and the nearby community agreement that we sent to him addresses that. And by the way, the format of the nearby community agreement is this wait and see approach. We enter into an agreement now, we agree that a year or so after opening, we will agree with the town on what things to study. We will study those items. We will get the report results. We will then meet and agree, or if we cannot agree, based on what you said last meeting, Mr. Chairman, I believe that disagreement comes back to the commission for a decision under the arbitration section of the regulation. That's the general format of the nearby community agreement.
Okay, great, thank you.
John's shaking his head no. No.
No, I mean, the arbitration provision under our regulations anticipates the arbitration occurring now to get to a surrounding community agreement. So the applicant is free to agree to that in some format independently in their own agreement, but it would not be the arbitration under our regs.
Yeah, I was going to correct council. What we put into the nearby community agreements is the integration of those provisions to go through the arbitration process. And I just wanted to back up so the commission understood exactly how we approached this process. We approached this process as the Carneys have always approached the surrounding communities and the nearby communities as neighbors, just as neighbors. They've been neighbors with these communities as a facility for over, almost a half a decade, and they continue to maintain those great relationships. So in kind of going forward with that, Tom and I initially, even before the application, we were a little ambitious, before the application was due, we met with every community that reached out to us, regardless of whether we thought they were significantly impacted, regardless of the legal analysis that was subsequently going to have to be applied by this commission. We wanted to understand exactly what the concern was. We also recognized that they were going to view the applicant's reports with a little bit of skepticism. So we integrated into these meetings the RPAs, both Serpent and Old Colony, to make sure that they had all the information that we had available. We gave them access to our information, and we wanted to make sure everybody had a comfort level that the information was objective. It is our information. It's just information that we've submitted to MIPA. It was in our ENF reports. All that information was made available per the regulations to all these communities, as well as to the RPAs. after listening to all the communities, one of the consistent themes we heard by everyone kind of around the facility is that they weren't certain what the impacts were going to be, and the anxiety was if they didn't do something, then they were going to waive all of their rights, which is completely understandable because I think we all sit here today not certain about what the impacts are going to be, significant, insignificant, or otherwise. So we formulated a nearby community agreement, which basically has the wait-and-see provision to actually analyze the impacts at that time. So that's the approach that we've been going forward with. That's the approach that we've kind of engaged everyone with. We've relied heavily on the RPA's assessments to the extent that when SERPID finished their analysis and came out with Middleborough being significantly impacted per the regulations, we recognize them as well. So this continues to be a collaborative process. We hope to wrap this up before the deadlines, and I think we'd hope that we could get all this done before today, but we're still optimistic that hopefully maybe we'll get it done before the 21st.
We are.
Right. Where do you stand with I forget if you gave this update, Mr. Bonner, but West Bridgewater. I'm sorry, you gave an update on West Bridgewater. What about Bridgewater?
We met with Bridgewater yesterday. That was the second meeting that we had with Bridgewater. We agreed to meet again next week to continue our discussion with them. The issue with Bridgewater is will we designate them as a surrounding community? We're still working through some of the data that they presented to us. You heard Mr. Dutton's comments today, taking a little different view on traffic flows and where traffic will come from. We will take that under advisement. We just got that information yesterday. It was that kind of information that we got from West Bridgewater, who we originally did not designate, that led us to designate them. They gave us some additional traffic information that we didn't have from our study. So we have shown that we're receptive to that information from the towns, and we have to review what Bridgewater shared with us yesterday.
In your wait-and-see package, how do you anticipate the suggestion in the statute that there is a weighting of good effects versus negative effects?
I think in the agreement we do take in, there's language in there about the net negative impacts. So the contemplation of recognizing positive impacts is in there. I can't tell you exactly today how it will be quantified, but there is a consideration for that.
Okay. We're looking for some help on how to quantify.
Yeah, so far we've put the words in the agreement. How we effect them remains to be determined.
All right, we'll try that too. Anybody else? Thank you.
You're welcome. Thank you.
Thank you.
Okay, that's the conclusion of that first part of the testimony, and I'll ask representatives from Fitchburg and the Cordish representative, Mr. Weinberg, whether or not they want to provide additional testimony regarding the disbursement. Fitchburg, can you join us? And Commissioners, I will note in your package, we have a very preliminary analysis that was completed by Green International regarding one aspect of the Fitchburg petition, namely traffic, and that's included in your packet. They're here today if you had any further questions about that preliminary analysis.
Okay. Did you want
Yes,
to speak? Okay.
thank you, Mr. Chairman, Commissioners. Again, I'm John Barrett. I'm the city solicitor for Fitchburg, and I'd like to convey the mayor's regrets, that Mayor Wong's regrets that she was unable to be here today because of other commitments. If she had been here, probably would have been here a lot longer today, because I know she had a lot to say. I'd like to just briefly, I don't want to reiterate what's in our application for, or our petition for recognition, but I'd just like to stress the fact that Fitchburg and Leominster are known as the Twin Cities. We do have a common border of approximately 7 miles. We do share a lot of our infrastructure with respect to the regional transit system. planning, Montechusett Planning Commission, and the housing collaboratives that we have. Fitchburg also, I think, has taken the lead, or has been a lead community dealing with a lot of social service agencies. And apart from the traffic concerns that we have, we have, I think, even a greater concern with respect to some of the negative consequences that can come from a gambling facility such as being proposed. We recognize that there have been studies, and I believe there's one particular one by the University of Buffalo, and correct me if I'm wrong, Bill, that denotes or observes the fact that communities that have a lower or socioeconomic, lower income population can be more adversely affected than other communities. Sadly, Fitchburg has a 19% poverty rate, which is twice that of Leominster's, and I'm sure much greater than the other surrounding towns. So that's one of those issues that we are concerned about, and it's very hard to quantify. You know, it's hard to determine exactly what effect this proposal is going to have. So with that as something of a background, what I particularly want to speak to is our request for involuntary disbursement. We feel that we needed assistance to deal with this. None of us in the city, particularly myself as the city solicitor or my assistant city solicitor, had any experience with this. Of course, this is all a whole new, brave new world with the Expanded Gaming Act, and so there's a lot of newness to this whole process. But I felt that we needed expert assistance in dealing with representing the city and counseling the city. And to that end, I was required to ask the council and the mayor for a special approval to seek the services of Mr. Devereaux and Mr. Fair and their firm to help us with this. Now, it was with the understanding, and quite frankly, the belief that we do have, quite frankly, it was with the expectation that we would be recognized as a surrounding community. We met, quite frankly, once with Mr. Weinberg and I forget the gentleman's name, but someone from the traffic folks. I believe it was from Whitman and Bingham, the engineers. And it was a fairly brief meeting for about 1 hour. And in that meeting, Mr. Weinberg basically extolled the fact that this is going to be bringing economic benefits to the city, and that there would be no negative consequences, and that they really had no intention of recognizing any surrounding communities. That's my recollection of the extent of our discussion. We were quite frankly taken aback by that, and we responded by making a proposal. Now, they have termed that proposal as being outrageous. And if it was, and I'm not saying that it was, but if it's determined to be, is in part due to the fact that this is very hard for us to quantify, and we needed the assistance of council to deal with these issues. I think, as I'm just trying to make an analogy, I think, you know, the applicant has suggested that they're willing to meet with us and negotiate, but it's their opposition to recognition as a surrounding community, and I guess their opposition to our petition for involuntary disbursement is akin to saying we're willing to play ball with you, but you know, you don't get a bat, you know, during the game. So I feel that I'm asking the commission to approve our petition for involuntary disbursement. We, I believe, need this assistance. And I guess just to conclude my comments, it's something of, I guess, a conundrum on my part, or confusion on my part. And I think that Chairman Crosby picked up on this. I don't understand how the logic of the applicant in terms of its interpretation of the act vis-a-vis what constitutes a surrounding community. it seems that what they're saying is that if you agree with what we're willing to give you, we'll designate you as a surrounding community, but if you don't, you're not, ergo, you're not a surrounding community. And the chairman, I think, picked up on this, is that the town of Townsend, which is approximately 14 miles from the center of Leominster, does not share a border with Leominster, has been designated as a surrounding community, but Fitchburg isn't. And there's something about that that just doesn't make sense to me. Hopefully it doesn't make sense to you. But with that, I would just ask that the commission favorably consider our petition for the involuntary disbursement and give us the means to deal further with our position that we are a surrounding community and should be designated as such. And I'd like to turn it over to Bill Devereaux, if I could.
Very, very briefly. I would note that, and I think the judge's questions to the applicant focused on this, that essentially there aren't any surrounding communities under the Act as far as the applicant's position is before the commission. But the law says that if an applicant enters into an agreement with a city or town, by law it's designated as a surrounding community. The logic then is, if you're recognizing these towns as surrounding communities, certainly Fitchburg fits within that definition. And then you can't, at the same time, use the agreements you've made with other towns as sort of the market for negotiations with towns that haven't come to agreements with you. So I would submit that it is relevant for the commission to consider. The types of experts that, I don't think it's any secret to the commission, we do need to focus on the traffic impacts. We do need to focus on the issue of problem gaming. The University of Buffalo study, which is very current, indicates that any town or city that has a significant number of people that are in the lower socioeconomic strata and within a 20-mile radius of a casino tend to get more adverse effects from problem gambling than other similarly situated, geographically situated towns. Fitchburg, frankly, I think fits right within that definition. The public safety impact, I would submit, needs to be examined as well. I would probably agree with the applicant that the police part of that is probably going to be adequately addressed if you have a substation. But there's definitely going to be an increase in responses by fire and EMT, and then you shift right into the whole mutual aid process. And those things need to be studied and put before the commission, and that's one of the reasons that we've asked for this disbursement. Thank you.
Remind me what the request is and where it comes from. How much of a disbursement are you looking for?
50,000.
50,000?
50,000,
And
yes.
what's the allocation of that? Where does that budget come from?
I don't want to defer to Bill. I think
It's a combination, obviously, of legal expenses, expert projected expert fees. Ideally, you try to get maybe somebody who can handle the public safety and the traffic study at the same time. If you reach out to the author of the study at the University of Buffalo, there's going to be a charge for that.
So then what's the makeup of the 50, more or less, on those categories? Just round numbers?
I would say probably 60% is going to be legal, because we're kind of boots on the ground and have been in this for some time now, and then would allocate the remainder to the experts.
Okay.
I have a couple of questions. In your the justification request that you present here, you identified the identical population demographically as a factor for requesting these monies. Help me understand why that is a factor.
That particular part of our presentation indicates a number of factors. One is the populations of the two cities are virtually identical. 40,000, I think Fitchburg might have.
In number.
In number, but we might be 200 people more. However, the poverty rate in Fitchburg is substantially higher.
That's on number 3. That's on your
Right.
factor number 3. But I'm talking about just the similarities.
It shows, because of the nature of how close these two cities are and the demographics, it certainly speaks, number one, to the issue of the problem gaming, because if you look at a study such as the one that came from the University of Buffalo, the negative impacts are probably going to be felt more in Fitchburg because of the lower socioeconomic strata, and that's one of the pieces of the information that we put before the commission. The other is concerning the roadways that traverse Fitchburg to get to the facility. Because on the one hand, when I hear Cordish indicate they're going to do some cross-marketing and they're going to do some advertising in the area, I would assume into New Hampshire, one of the ways to get to the casino is through Fitchburg. So there's going to be potentially negative, when I say negative, it's going to be more use of the roadways, which leads to the depreciation of the roadways. And we certainly don't sit here saying, oh, gee, Cordish is somehow is responsible for the problems that Fitchburg has. That, frankly, is an absurd notion. No, the question is, are they going to, is this type of gambling going to exacerbate the situation Fitchburg is now in? And we need the disbursement to adequately address those concerns.
I want to understand. I want to stay with the issue of problem gambling for a minute. It's something that we've thought a lot about. We are doing a big study, as you may know, that will begin to measure to have a baseline measure and eventually have a real impact measurement, state level and regional as well. How do you propose that this factor could be studied with the 50,000 that you're requesting?
Well, I would hope that what we would do is we would reach out to Dr. Welty, who wrote the study. I'm aware, I believe the commission has consulted Father McGowan from Boston College, who frankly is I think, a well-respected expert in this area, not only the economics, but he's also studied the issues of the negatives, the problem gambling aspect of it. Why the Buffalo study stood out to us and why we would want to explore that is because Fitchburg seemed to fit right within the demographics that study was talking about. We are going to be within 20 miles of this casino. It is it's an entertainment venue. People go there to gamble, they go there to eat, drink, whatever. But the fact is there's going to be increased population flow into that facility, and based on the studies that we see, the one from the University of Buffalo, the negative aspects of that could certainly adversely affect Fitchburg, perhaps more than others in the region.
That may be the case, but there's a lot of money that goes to this particular issue already earmarked in our legislation.
I would just add to I just put an even finer point on it. I mean, to preview where I'm coming from, I think my guess is we may not be deciding this at the moment, but for you to look at the problem, for the community to look at the problem gambling issue is akin to the surrounding communities trying to do better than our background checks. I mean, it makes no sense. The amount of money that's being done to attend to both host community, regional, and statewide baseline conditions, impacts of expanded gaming, treatment, programmatic responses there too. utterly superfluous, in my opinion, for an individual community to think that you'll be able to enhance that. Traffic I can't speak to, but that one I would very much reinforce Commissioner Zuniga's point.
Perhaps you're not aware of the dimensions of that, but we could certainly send you the link to the website for the study, and you can see what's there and what's being done.
We would appreciate that. We're not, let me emphasize, we're not trying to reinvent the wheel, but when you have a city that, in essence, we're trying to justify first that we're a surrounding community, and secondly, if we have to engage in, if we can't come to an agreement, we would hope we could with Cordish, but if we can't and we have to go to an arbitration, we do have to have a bat and ball to play the game. And we have to project as best as we can. In some ways, we're shooting in the dark in terms of what types of expert evidence we would have to give and why Fitchburg is different.
Yeah. I don't think we're disagreeing with that. We're just saying this particular one, you might be barking up the wrong tree, but you know, that's for you to.
Well, I might, I'm sorry.
Please go ahead.
I just, one thing, I think I hear what the Commission's saying as far as the other provisions for problem gambling individually, but I think that what we're concerned about too is somewhat the residual effects. Someone who has a problem with gambling, spends their paycheck, can't pay their rent, applies for fuel assistance. Those are some of the needs, just briefly, that are going to fall back on some of the services that the city will particularly have to try to respond to. So it's very difficult to try to quantify that again, but it goes beyond just a person that's got, you know, problems with gambling. And I'm not sure, I really don't know if the funds that are available through the Act would address those, but we're concerned that that's going to fall back to the city with lack of housing, people losing their housing, getting evicted because, you know, they didn't pay their rent. Those are kind of societal impacts that could, we feel, have a bearing on our ability to deal with those problems.
Can I
Just
move
to
on?
one last thing. It might be relevant as to whether you're a surrounding community or not. I was bringing it up in the context of your $50,000. I think you could think of better ways to, if you get your $50,000, you could think of better ways to spend it. It may be relevant to whether or not it will have a negative impact on you, but I was speaking to how you're going to spend your money.
All right, thank you, Mr. Chairman.
Well, I had a question, but it would be the same theme on other factors that you list here. You say that there would be potential stress to the city's housing stock, particularly as it comes to inspectional services or to ensure proper code enforcement. Do you have the petition in front of you?
I left it over there, Mr. Commissioner, but I think the issue there is that, and again, we're at a baseline where our resources for dealing with housing problems and state sanitary code is less than what we really need to have. So we're not laying blame to the applicant for that. But what our concern is that if one scenario is, quite frankly, that the employees that may work for the applicant, they're not all people that are going to be making $50,000 and $60,000. They're going to have some folks there that are going to be in the lower economic income levels. And there's a great likelihood that I think a lot of those people are going to gravitate to Fitchburg for their housing. We have a fairly high vacancy rate. We have a housing stock that is generally old and dilapidated, and so we're going to have more people that are going to be, I think, working at the applicant's facility that will likely come to Fitchburg for housing. And I don't know, Bill, if you can, and I guess that's borne out by you know, information that we've received from the Montechusett Opportunity Council. That's one of the social service agencies that we have in the area that they expressed to us a concern that this is a potential problem, and that would put a stress on our ability to inspect and follow up with code enforcement to protect the housing for people who will work at the facility.
But you already have those resources existing, don't you?
They're inadequate. They're inadequate. I mean, and the fact that we expect, or we believe, that there's going to be more stress put on that, because if, I forget quite frankly, I forget the number of people that are expected to work at the facility. But, you know, if you have...
400 or 500 people. And you're a
thank
city
you.
of 45,000.
You know, there's going to be, I think, a significant proportion of them will look for housing in Fitchburg. And, you know, what a lot of our housing stock is older, you know, 3-decker tenement housing that's pretty old, and it needs to be, the code needs to be enforced, and they need to be upgraded. We don't have the resources with our inspectional services to go out there and sort of get people to bring the properties up to code so that people are living in safe homes. So.
But I don't want to resolve this now, but there's a commitment to hire local people. That's part of the host community agreement, that's part of the pitch that's been made, that's part of the things that the commission is looking for. So part of what the commission is going to be looking for, part of what it's going to be expecting of the applicants, part of what's in this host community agreement is to hire local people. Those people already have homes, so they may be upgrading them, but...
And you could always ask people not to move to Fitchburg. I mean,
Right.
If you think that's a net negative, you know, having people move to Fitchburg, you could try to discourage that.
I don't think we're suggesting that, Mr. Chairman and Mr. Commissioner, but I think that that's something that we perceive that there's going to be a need, you know, with respect to housing resulting from the facility. And ideally, they will, you know, live in Fitchburg, you know, and quite frankly, Commissioner, as to your point about that there's going to be hiring from the area, we really don't know what specifically. I can't remember, quite frankly, you know, what commitments to Leominster preclude, you know, the hiring that would go out beyond that. I suppose that, you know, certainly I'm sure they're going to be, what we perceive is they're going to be people that will live in Fitchburg, that will work there, and that will be a good thing. I agree with you. But because of what we perceive, at least, as the economic situation, where they're going to be living is in some of the housing that is you know, needs code enforcement, needs work. So we feel that we're going to have need more assistance with that.
Could I also assure the commission that we're not looking for some sort of a blank check to go out and hire this candy select different experts? We want to, there are certainly going to be some issues that are going to have, in the city's judgment, more potential for a negative impact. And those certainly are where we would advise the client to spend their resources. But as it is now, when you have a city that comes into a situation like this and really does not know what they're facing, they have to be properly advised, especially if they're going to be in an adversarial situation where the applicant is saying, first, you're not a surrounding community, and if you are, you should take what we give you pretty much without question. We would certainly, and I'll assure you again, like to talk to them and have a two-way dialogue to see if we can get somewhere in the meantime. But we have to prepare for the worst-case scenario. And that, in essence, is why we are before you and looking for what we projected to be a fair enough number to accomplish what we need to do. We're not going to reinvent the wheel and have a huge gambling addiction study. I'm aware that it is a minority percentage of the people that go to these facilities. That's what all the studies show. The question is it going to affect a certain type of a population more than another? That's sort of a narrow analysis of the issue. And those are the kinds of things that we would focus on. In terms of the housing, we would have to obviously take a cursory look at that first. There's going to be more jobs if this happens, which is a good thing. But it's not going to be a panacea. I mean, you're going to have some high-paying jobs in the tech, area and some of the business managers, but after that, it pretty well drops off. Those are going to be service jobs. They're going to be people that watch the VLT machines. There's going to be retired police officers that are hired to be security people that go around the facility to make sure that things are on the up and up. And then there's going to be service people at the restaurants. Most of these places are fairly self-contained. It'll be great if there's this networking idea that has been touted, but I'd submit that that is probably not that likely. I think what you're going to see is a fairly self-contained entity. It's good that they're going to have the police, but there's going to be a number of EMT calls that are made, and the statistics show that. So those are the kinds of things Fitchburg needs to, we've got to be able to come before you or whatever arbitration panel, if it gets to that point, and be able to put some of the kinds of statistics that Cordish was able to put up on the screen today. And that's essentially why we're here.
I got to ask one last question, because this is the last factor that you cite in your justification, and that's the impacts, potential impacts to the city school because of including bilingual education.
That's not us.
I'm familiar from 2 jobs ago that Fitchburg already educates about twice on a percentage basis compared to statewide average non-English speakers. So you already have effectively those programs. You're already required to have those programs.
Mm-hmm.
Is that not the case?
Yes. And the question really is, what is the extra strain on those programs? That's what we want to look at. But we already have those programs.
Anybody else?
No, thank you.
Just for the record, I did raise the issue about if towns in the surrounding community, maybe that says something, and the applicant raised a nuance to that, which I think reasonable men could understand, so don't conclude from what I said that that's the end of the conversation. Anybody else? I think that, I think there's enough issues here, particularly on the traffic side. I think we have some data on the others that we can be sort of commonsensical about, but I think we would want to hear the traffic one is the big one, and our own studies, our own peer review are not dispositive yet, and they don't feel like they've really had a chance to do the job. So my suggestion would be that we wait on this, get the staff report, and decide on this on the 21st. Does everybody agree with that? To be sure, I think it would be safer for everybody if you guys could figure this out, and I understand that's easier said than done, but the arbitration process probably is too, if that's what you end up involved in. Okay?
Thank you.
Thank you.
Okay, thank you.
Mr. Chairman, we do have, and Catherine would like to make a few comments on the impacted live entertainment venue.
Okay, and to be fair, if I spoke too quickly, if the applicant wanted to respond as well, feel free.
Always.
Except that the applicant just won,
Pardon?
at least for today.
Yeah.
And I'll be brief. But for the record, we've opposed the petition from Fitchburg for a number of reasons. One, the application. Well, first, for my prior discussion earlier today, we believe that they don't meet the definition of a surrounding community under the statute. And again, the statute there is several ways to become a surrounding community. One is through an agreement with the applicant. The other is to petition and show you meet those tests. and we believe they don't meet those tests, and therefore to disperse money when they should not be found in the surrounding community, that's why we oppose it. But secondly, the application has no specificity, and I think you all just kind of zeroed in on that, on the use of the monies. So the city has clearly had enough time to define exactly what it needs to study, to have a scope of those studies, to have gone out and gotten bids, to conduct those studies. So with specificity, they could have come forward and given us definition as to exactly what they were trying to achieve. Having done a lot of market research in my day, typically you don't spend money unless the answers you can get from those studies rationalize the expenditure of money. The commission is doing the traffic studies, so to spend more money on traffic studies when the commission will be looking at that issue, I think is not a reasonable expenditure of funds. You talked about the problem gaming issues, and I'm not quite sure where else other than the legal fees that the money is going to go to. So, those are the reasons why we oppose the application. Just to mirror some of the comments, some of the issues that were outlined as things to study, such as, the housing stock. Clearly, we can either hire people from Fitchburg or not hire people from Fitchburg. We can encourage or discourage people from living in Fitchburg. I think we all realize that having people move into an area is a net benefit, and that's how you get housing upgraded and you get income flowing into a community. So we can work with the community in one way in terms of positively trying to encourage those types of working with the community, or to discourage it. So, but I also want to give you our commitment that we will try as hard as we can to work with the city of Fitchburg. Hopefully we can spend some time after this meeting. And I will also make a commitment for the 3 communities that we are opposing their petitions for surrounding communities, that we will keep open our offer for the cooperative agreements that we have, notwithstanding the commission finding that they don't meet the tests of surrounding communities. And we're happy to put that in. I mean, we're making the commitment right now, but we're prepared to do that because we, at the end of the day, we want to have this cooperation with all of our neighboring communities.
Go ahead, sorry.
No, that's an important point. In other words, if we don't deem them to be a surrounding community based on a definition or the factors, you will still be willing to work in a cooperative manner.
Absolutely. And in fact, we're happy to put the agreement that we have done with others in escrow, or
we'll take that on.
We're prepared
to take that on, Faith.
Yeah.
When you had the opportunity to do work with an RPA for a region-wide deal, what was your reaction to that?
In terms of the Wachusett regional?
I forget which agency it is, but
they took a look at they attended the MIPA gathering, gave their comments to that, I believe. They did issue, I think, a report.
But I meant the process that we offered of having, that we would fund, or eventually you would fund, the RPA sort of being the honest broker for many, if not all, of the surrounding communities.
There really has been no discussion on that direction.
Well,
the RPA did look at certain things, but
but I mean, we've had numerous conversations about the availability about the RPA program, and it's a voluntary program by applicants and communities.
And
it was up to the applicant to take advantage of that program.
And the applicant elected not to. In this case, the applicant elected
Yeah.
not to use that resource, right?
Yeah, and in fairness to Mr. Weinberg, it wasn't clear that the RPA was wanted to pursue that, given where it was in the process at that moment.
Okay. Just one thing, I mean, I take some of your points, but there is a catch-22 in our process. The poorer and smaller a community is, the less resources it has to make the case to us that it either should have an involuntary disbursement or become a bidder. And, you know, we've done everything we can to try to accommodate that. This is a very poor town. You know, on the one hand, the offer of free legal services will try to get it out of the applicant is a little obnoxious. On the other hand, fortunately, somebody's willing to step up and help a town that's a real poor town. You know, so it's not a one-sided matter. And I think this is a weakness. I'm not sure it's a weakness that could have been fixed, but it is an inherent weakness in our process that the poorer and smaller you are, the less you've got a chance to come to the table with some kind of tools to have serious negotiations.
Yeah, but the city has had the benefit of the representation of council. They've had significant time to prepare their arguments and to identify what it is that is critical in terms of potential impacts and what they needed to study. And I think they've failed to do that. Just the minimum of coming in with, we need to do this study, here's the scope, here's the cost, here's the bids that we've accepted. That doesn't cost anything to go out and solicit those bids. And unfortunately, it leads to a lot of, for want of better words, throwing everything up against the wall to try to make a case. And it's very difficult for us as an applicant or any applicant to try to deal with everything in the world that could potentially be a problem without trying to define with specificity something that you can try to sink your teeth in and try to address.
Anybody else?
Thank you.
Thank you. Thank you. If that doesn't change what we talked about before, then I think we will sit on this and get the advice of our staff and consultants and talk about this next week.
Well, we
Do you wanna-
really are committed, as I understand the process, to next week deciding who the surrounding communities are, so that this is simply a request for a payment in advance of the designation, which our regulations permit. But once a community is designated a surrounding community, certain rights flow with that designation. So this, by not deciding the advance payment today, I think we are basically taking the advance payment issue off the table. We're not taking a payment issue off the table, but we're taking.
And thereby costing Fitchburg a week's worth of time.
That's right.
Potentially.
That's right.
Yeah. Well, I mean, that's a fair point, but I don't feel like the primary criteria is a reasonable likelihood that the community will be designated a surrounding community. And I don't have an opinion on that.
Yeah, I don't have an opinion on that one way or the other. I just, the burden of proof.
No, but you're helpful. The clarifying the impact here is
Right.
helpful, and I didn't write that. Do you have a general counsel?
We have one more matter. It's an impacted live entertainment venue matter. We've received 2, perhaps 3 petitions. We've monitored them, and all but one have resolved over time. The process for designation of an impacted live entertainment venue is very similar to a surrounding community. And as of late in the day on Tuesday, we understood that there was one venue. It is the South Shore Music Circus that remains unresolved. And so they will put a petition before us to be considered as an impacted live entertainment venue. We weren't sure whether a representative would be here today to just brief the commission on that, and we do in fact have a representative. So we'd like to give them a few minutes to explain their petition. We will put their formal petition in the book for you next week, and you could decide on that at that point, just as you would with the surrounding communities, to accept or deny their petition. But we do have a representative who would like to say a few words, so.
Is there any technicality that this came in just 2 days ago and we didn't have a chance to get it on the agenda? Is it all right? Is it all right under the item you're bringing it up as opposed to the unanticipated?
We think it's the same process. Essentially, it's a different item, but we think it's a very similar process. So we'll just let folks speak to it, but we will put it on the agenda
And we won't
specifically for
decide.
next.
Okay.
We won't decide today.
Okay. Good. Aye.
Good.
Aye.
Afternoon.
Yeah.
Happy to be here, but sorry to say good afternoon rather than good morning. My name is Peter Martin. I'm an attorney at Bowditch and Dewey in Worcester. What I'd like to do, Mr. Chairman, if the commissioners are agreeable, is for me to begin by reading a short statement and then turning the podium over to Mr. Siebels and Mr. Longo, who will also deliver brief statements. Copies of the statements have already been made available to the commission, and then we'd be happy to take any questions you might have for us. So as I say, I'm Peter Martin, partner in the law firm of Bowditch and Dewey in Worcester. I represent the Massachusetts Performing Arts Coalition, Incorporated, a Massachusetts nonprofit organization created in August of 2012. MPAC is organized as an association of not-for-profit or municipally owned performance venues located in Springfield, Worcester, Lowell, Hyannis, Cohasset, Lynn, and New Bedford. MPAC was created to promote the general welfare of member theaters and of the touring entertainment industry in Massachusetts, to facilitate collaboration and cooperation between and among its members, and to facilitate equitable and transparent agreements between its member theaters and Massachusetts casino licensees, as contemplated in Massachusetts expanded gaming legislation. MPAC has 6 members with theaters. One of the members is South Shore Playhouse Associates, which operates the Cape Cod Melody Tent in Hyannis and the South Shore Music Circus in Cohasset. When I refer to South Shore Playhouse Associates, or SSPA, I will be referring to both venues. Now, South Shore Playhouse Associates is a nonprofit Massachusetts corporation created in 1948 and is tax exempt under Internal Revenue Code Section 501c3. As I said, I'm sitting here with Troy Siebels, the president of MPAC, and Vincent Longo, the chief operating officer of South Shore Playhouse Associates. We'd like to give you some background information about MPAC and South Shore Playhouse Associates, describe our interactions to date with Raynham Park LLC, and explain why we believe SSPA's 2 sites are both an impacted live entertainment venue under the expanded gaming statutes and its associated regulations. As you know, under Section 2 of the statute, an impacted live entertainment venue is a not-for-profit or municipally owned performance venue that is designed in whole or in part for the presentation of live concerts, comedy, or theatrical performances which the Commission determines experiences or is likely to experience a negative impact from the development or operation of a gaming establishment. Regulations promulgated under that statute state that an impacted live entertainment venue shall be a venue located in the Commonwealth that has executed an impacted live entertainment venue agreement with a gaming licensee applicant, or one that has been designated an impacted live entertainment venue by the Commission. Under the first prong of the regulatory definition, in order for an executed impacted live entertainment venue agreement to establish the venue as an impacted live entertainment venue, that agreement must be submitted with the RFA2 application and be in compliance with Section 15, Sub 10 of the expanded gaming statute. If such an agreement has not been finalized and submitted as part of the application, the parties have 30 days after the impacted live entertainment venue designation by the Commission to conclude such an agreement. The statute requires an impacted live entertainment venue agreement to provide at a minimum terms related to cross-marketing, coordination of performance schedules, promotions, and ticket prices. Under the second prong of the regulatory definition, the Commission is to consider certain factors in making the determination that a venue is an impacted live entertainment venue. Regulation provides a non-exclusive list of factors such as the distance of the venue from the gaming establishment, the venue's capacity, the type of performances offered by that venue, and whether the applicant includes a geographic exclusivity clause in its contracts with entertainers or otherwise intends to limit the performance of entertainers in Massachusetts. Mr. Siebels will describe to you the efforts of MPAC and South Shore Playhouse Associates to enter into an impacted live entertainment venue agreement with Raynham Park. Mr. Longo will describe to you the characteristics of South Shore Playhouse Associates that qualify it as an impacted live entertainment venue. The preference of MPAC and South Shore Playhouse Associates is to enter into an impacted live entertainment venue agreement with Raynham Park, and I believe we are close to concluding such an agreement that meets the statutory requirements. However, because we had not concluded an agreement with Raynham Park within the 10-day period after the Commission's notice of receiving Raynham Park's application, we filed the petition for impacted live entertainment venue recognition that is the subject of today's discussion. I will note that the following characteristics of South Shore Playhouse Associates entitle it to an impacted live entertainment venue determination from the Commission. The two venues in question are owned and operated by a tax-exempt nonprofit Massachusetts corporation that presents exclusively musical performances at South Shore Music Circus and Cape Cod Melody Tent. For the specific reasons Mr. Longo will describe to you, as a result of the operation of a live entertainment venue by Raynham Park 24.5 miles away in the case of the Cohasset venue and 45 miles away, Hyannis, which is likely to offer performances similar to those presented at SSPA's two venues, it's almost certain that South Shore Playhouse Associates will experience a decrease in attendance and other negative impacts due to the proximity of competing performances at the Raynham Park site. These negative impacts will likely be felt by South Shore Playhouse Associates even in the absence of an exclusivity clause binding entertainers at the Raynham Park site. As I stated earlier, MPAC and South Shore Playhouse Associates have over the last weeks discussed the terms of a proposed impacted live entertainment venue agreement with Raynham Park, and I believe that we are close to concluding a mutually satisfactory impacted live entertainment venue agreement with Raynham Park. The current draft proposed impacted live entertainment venue agreement contains all of the minimum terms set forth in the statute. The Commission's designation of South Shore Playhouse Associates' two sites as impacted live entertainment venues will permit those discussions to continue and hopefully conclude successfully within the 30-day period called for in the regulation. Thank you.
You lost me with that last sentence. I thought you were saying that you feel confident, quite confident, that there will be a resolution to this.
Yes.
But then you said we would need, which I thought you meant maybe in the next few days, so maybe we don't have to decide this on the 21st.
It's my deepest hope that that would be the case, but I can't guarantee that's going to be the case.
To be respectful of your time, I will paraphrase a little bit, and I'm prone to speaking quickly, so that'll work to our benefit. Good afternoon. Thank you for the opportunity to speak with you again today. The elements of the Expanded Gaming Act that were created to protect existing performing arts centers included, as you know, the opportunity to sign these letters of agreement. That process is working as it was intended. Our group of performing arts centers throughout the Commonwealth has been in contact with every single gaming applicant. We have signed agreements with 3 of those applicants. We are in friendly conversations and close to finalizing 2 others. As we recognize that the deadlines for the slot parlor applicants were sooner than the others, we prioritized those, and we have signed agreements with both Penn National and with Cordish. We did reach out to Raynham Park with a letter on June 6th, asking to meet to discuss their plans, and then we followed up with a letter on September 9th, with which we included a draft copy of an agreement identical to the one we signed with Penn National. With no response to that, and with the Category 2 deadline looming, we contacted the Commission with a letter on September 27 to let you know we'd been working to contact and engage them, and followed it with an email to the Commission on October 8. Mr. Grossman in Ombudsman Yemba's office was very helpful in forwarding that email to Attorney Lee and offering Raynham Park an opportunity to respond. We didn't hear a response, and we followed that up with an email on October 31st, to which we did get a response, and were able to schedule a call for that afternoon. And it's at that time we first learned that Raynham Park LLC did, in fact, plan to present live entertainment, and so it sort of took on a new importance for us. We sent some suggested language that we had developed in conversations with some of the other license applicants, we understand Raynham Park had a great many things on its plate, clearly, and it would have been great for the opportunity to speak and deal with this back in June, but we're happy to begin discussions with them now, but simply have not had time to finalize an agreement in the past week and a half. I concur with Peter. We have no doubt we'll be able to successfully finalize an agreement, but not having done so yet left us with no option but to sit before you today. We've appeared here several times and presented a lot of evidence that our venues are at risk of impact. Our experience operating in conflict with the Connecticut and Rhode Island casinos gives us new evidence every day. We have, down to pages and pages of detail, 4 years of performances at our venue and the 2 Connecticut casinos, and which performers specifically were lost to those casinos and which would likely be lost to Massachusetts casinos. We understand that the question before you today is a narrower one, whether South Shore Playhouse Associates qualifies as impacted under the statute as it relates specifically to Raynham Park, and I'll let Vince speak to that. But I take the brief opportunity to comment on Attorney Lee's letter yesterday stating that the Cohasset facility is 36 miles from Raynham Park and not in close proximity, and that it appears unlikely that patrons will forego events in Cohasset specifically to go to events at Raynham's Park. Ironically, Raynham's Park application identifies its primary market area as a 90-minute drive, and it makes the case that potential gamblers from that area are in close proximity. So I think it's fair to say that the venue is. It really misses the point, though. Our chief concern is that we have the opportunity to continue to present headline performers at our venues. If all those performers appear at Raynham Park, then the patron doesn't have the opportunity to make the decision whether to go to Cohasset or to Raynham to see it. Our goal continues to be to have the opportunity to engage in these productive conversations with the licensees to create a level playing field. Vince?
Vince Longo, Chief Operating Officer for South Shore Playhouse Associates. We are the last 2 continuously operated theater tents in the United States. Started out with 14 of them. We were the last 2. The Music Circus and the Melody Tent are owned by South Shore Playhouse Associates, and we've started doing business in 1932. We're interwoven with the fabric of our communities, and we have a great amount of history that brings us to where we are today and how we want to maintain and keep ourselves in business in light of the fact that casinos are going to be challenging us with the buying of talent. The Music Circus and the Melody Tent take revenue generated from our ticket sales and reinvest that money into our community. We're a very different 501c3. We do this to help keep our community stronger in the arts. SSPA venues are 2,300 seats each. We consider ourselves as an impacted live entertainment venue for the following reasons. We have been working on our cultural identity for over 60 years. We're very concerned that new casino business does not drum out any of the nonprofit and municipally owned live entertainment venues in our communities. We live and die by the ticket sale. We're very different than other 501c3s. We don't accept money from any government agencies, and ticket sales is our core business. The major problem with this situation is the supply side of the equation. If we can't get the talent at a reasonable rate, we can't operate. It's very clear that casinos, and any major agent will tell you that casinos always pay more than theaters. They have all the money. That's why they can pay more. And with that, some of the loyalties that are usually built up for venues like SSPA around the country kind of go away with the money being put in front of these artists. And we risk without changing some of this attitude with how we can get our talent, it's going to be difficult to stay in business. We already have somewhat of a level playing field with competitors like the guy sitting next to me and all the other people in the coalition to go out and get this talent within certain periods of 18 to 24 months because 95% of all managers do not go back into the same community within a year. So a radius clause is nice, but it's not everything that it's cranked up to be from the casino side. We've put $3.7 million back into our communities. And we've reinvested this in other 501c3 arts organizations. If we weren't around, that wouldn't happen. SSPA is unique in that it is an impacted live entertainment venue because it's seasonal. We're the only seasonal live entertainment venue that will come before you. Our performances run from Memorial Day through Labor Day. We start advertising our shows in the beginning of January. Distance from Raynham Park to Cohasset is the distance is 24.5 miles, and from Hyannis is 45 miles. I'm just going to skip to some of the examples. It's just easier. You have a letter from a guy named Larry Bonoff, who ran the Warwick Musical Theater. Larry Bonoff states in his letter what it was like to gradually go out of business because Foxwoods and Mohegan Sun opened up. First off, 25% of his talent was taken, was pilfered right off the top. I can give you some examples now of similar situations that have happened to me at South Shore Playhouse Associates. In 1994, Harbor Lights opened up right down the street here. Now it's the Bank of America Pavilion. That first year, in 1994, certain acts such as Tom Jones, Steve Lawrence, and Edie Gourmet, Diana Krall, the Moody Blues, Crosby, Stills, and Nash, all left my venue in 1 year. They all were gone. We struggled to stay afloat because of that one action. In 2013, Live Nation took over Newport Yachting Center. Due to the company's strength in the market and the ability to book and pay more than nonprofit theaters can pay, SSPA lost acts such as Styx, Tony Bennett, and it resulted in a down year. Most acts limit the amount of plays that they will take in Massachusetts. So middle-of-the-road acts play where the money is. SSPA's lost performances to Foxwoods and Mohegan Sun from the day they opened. I hope I just kind of give you like a balance of where we are within the nonprofit organization theaters in Massachusetts and what could be affecting us.
Have you done any, you've looked now at the Raynham proposal, right? And you know the size of the multi-purpose center that's there, right? Mm-hmm. And you know there's a donut hole in what they can do. They can't do between 1,000 and 3,500. Mm-hmm. And you know that in all likelihood, by looking at the facility, it's probable that there'll be 1,000 or under if they do use that for performances, right?
That's what we, yes, that's what the law is.
Okay, so I mean, that's your plan.
Yeah.
So how does that kind of a venue compete with a 2,300 seat venue and the kinds of acts that you were booking in either of the two venues you're talking about?
Sure. If I may, Commissioner, the same acts play for a fee. You know, if you book Aretha Franklin for $100,000, she'll play a 2,300 seat venue or a 999 seat venue. I would not, as a nonprofit operator, be able to put a pro forma together that would make that work at 999 seats. But if it is not my core business, if I'm using that to draw people to the facility to game at slot machines, the equation might be different. And we have found that it's different at casinos elsewhere. The same acts do play both places, and that donut hole was a compromise legislatively. It's certainly not where we started.
And do you have studies that show your loss of, or experience that shows your members' loss of business to 999 seat venues?
I have a study that shows my venue's loss of business to the Connecticut casinos venues, including the 400-seat space at one of those two venues. I could separate that from the experience we've lost to the larger venue as well, yes.
I can do the same thing. They're paying sometimes double, most of the time 1.5 times the going rate for the act. The casinos will put it in any size room.
Okay. Thank you.
So do acts they don't charge a flat fee no matter the size of the venue. If you go to Gillette, you're gonna get a bigger fee. How does that?
Sure. Well, you can book an act for a flat fee, which would be a healthy flat fee. Normally they look at your gross potential ticket sales, and they'll say, I want a guarantee of $75,000 versus 80% of the gross ticket sales, whichever is greater. So it makes a difference to them what your capacity is and what your ticket prices are. However, a casino venue will often give away a disproportionate number of those tickets as comp tickets to gamers, and often will lean toward a flat fee and pay extra to get the artist to accept that flat fee in order to have the ability to do that.
I think the difference is that with SSPA, our core business is putting arts and entertainment up front first. That's what we're about. The difference is with some of the casinos, and we're going to actually talk about this later on too, when the casinos come in, other than the slot parlors, is that it's not their core business. And this is money that just goes for marketing.
Well, and if I may, hopefully we won't talk about this later. We are in process with all of the licensees, potential licensees, and working with everyone.
When you mentioned that you were close with two, you mentioned the ones that you already have agreements and that you were close with two. Was Rain and Park one of those two?
I did not include it as one of those two, but I believe that we are also close with Rain and Park.
Keeping in mind, we didn't know until October 28th that they were going to have live entertainment. We tried to get in touch with them June 31. We tried to get in touch with them June 6th. So they just didn't respond.
Anybody else?
Okay.
Okay.
Thank you very much.
Thank you.
Yeah, does, the applicant get a chance to
Yeah.
say their 2 cents worth? 1 to 2 cents worth?
Good afternoon now.
Good afternoon.
I did get those correspondence, and I think I was confused initially. We were busy, so I don't want to misrepresent. When we initially got the correspondence, I was responding to other things. I do have to say it was under like the Hanover Theater, so there was a disconnect for me as to which theater we're talking about, because I automatically associated that with Worcester over there. But with that being said, we're very optimistic. I think we're very close. I think since the time we have focused on this, this might be a prime example of over-lawyering. I think we're working on terms. That's all we need to get out. I am very optimistic. Spoke to counsel. He's also optimistic. I can't imagine it's going to be a problem. I don't know, Tom, if you want to add.
Yeah, I think the most important part of the venue's presentation was the statement that we're very close to an agreement, and we are. In that agreement, we designate South Shore as an impacted community. As Grace said, we're just down to working out the details on some of the terms. We've been back and forth with a couple drafts. I'm optimistic that when we sit here before you a week from today, we'll have a signed agreement.
In which case, you won't be sitting before us.
On other issues, we may be.
Oh, yeah, right, okay.
So, clarification, you're talking with them about South Shore, but not the Cape Cod Melody tent? Or are you talking about them both venues?
In all of our discussions thus far, prior to their petition, we had focused on the South Shore location because of its proximity. And I believe that their petition is limited to South Shore, so our agreement had addressed only South Shore. Am I missing the point on that?
Is that accurate? I mean, something in front of us
I believe they
says
just-
Cape Cod is also.
Yeah, they did just say that both of them, they just mentioned that they were
Okay.
considering both.
Well, then we will address that. To date, though, our focus was on South Shore. If they want us to include the other location, we certainly will, and we'll try to come to the agreement as well.
Good.
It's confusing because of the name, too. You use
There's a
South
lot of
Shore.
names
You
under
use
the
South Shore
umbrella,
twice,
so,
yeah, right,
yes.
right. All right.
Okay, great.
Thank you.
Thank you.
All right, thank you.
Thanks.
All right.
We have one final matter.
At our last meeting, we were grappling with the motion that we needed to make in order to grant a variance under section, I believe it's 125. With some assistance from Mr. Ziemba and Commissioner McHugh, we do have a motion for the commission to entertain, and this will allow the waiver of the timeframe between designation of the surrounding communities and the hearing in the host community, and also allow the commission to take executed surrounding community agreements after the filing of the RFA2 application.
So the first of the two motions that I'm about to make deals with the provision of our regulations that says a surrounding community exists if there's a surrounding community agreement signed between the community and the applicant, and by the date that the RFA2 application is filed. And there were some that were signed after that, and there's no reason why, as we discussed at our last meeting, we shouldn't consider those communities, surrounding communities. So this motion that I'm about to make is designed to deal with that, and I move, therefore, that the commission grant a variance from the provisions of 205 CMR 125.01 to provide that a community which has executed a surrounding community agreement with an applicant is determined to be a surrounding community, although the agreement is submitted after the filing of an RFA2 application.
Second. Any discussion? All in favor?
Aye.
Opposed? Ayes have it unanimously.
And the second one is designed, this is one we sort of struggled with on the fly at the last meeting, and this is designed to not be on the fly. But it's designed to deal with the timing of the hearing in the host communities, the statutory hearing in the host communities, and allow that a variance from our regulations to accomplish that on the schedule that we've set out. So I'd move that the commission grant a variance from 205 CMR 125.01 parent 2 to provide that the commission may hold the public hearing required by General Laws 23K, Section 17C, less than 30 days after the designation of surrounding communities, so long as all designated and petitioning surrounding communities have received at least 30 days' notice of the hearing as required by 23K, Section 17C, and provided further that the hearing will not close until all surrounding community agreements in the region have been created and the surrounding communities have had an opportunity to be heard.
All surrounding community agreements have been created?
Yes, and that's to take into account either that they come into existence by a mutual agreement or as the product of an arbitration process.
Second.
Discussion? Ayes?
Aye.
Noes? Ayes have it unanimously. All right, we need to make a policy decision. It's basically 1 o'clock, and I think maybe we ought to take a break and just, we can go next door to the restaurant or something, get a sandwich, and I don't want to feel like we just have to rush through these things. If we can do it quickly, fine, but I don't want to feel like we're all sitting here under the gun. Is that okay with everybody?
Yes.
So let's, there's no way, we can't eat anything here, right? So we could go just go to the restaurant or somewhere. All right.
There's a lot of workers downstairs. Maybe somebody brought an extra lunch.
Yeah. Let's do it till 2. Take a break until 2.